Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
LJ commentary on the case. Dati mihi Anglican for East Service Montana. I didn't ask you to interrupt me.
Is that correct?
Oh, for front seat.
Apparently that camera is not working. Let's fix it, shall we? Happy Friday to you. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Good to have you here. I am blurry as all get out. What is happening here? F1.4. Who's been messing with my camera? There we go. Happy Friday. I'm hoping all of y'all are safe and sound and dry. Give me just 1 second. We've got people checking in all over the place. That's not right. Well, was there a hurricane in my studio last night? Sample user, congratulations. No, Denise Feldman Ersland, congratulations. You are first in chat. The internet is all yours. It's going to be a busy day, Denise. I know you did some great court watching for us. You've been busy. You're driving back and forth. Coburg, it was great. But that was yesterday. And this is a little bit like, what have you done for us lately? Meaning today. You being first in chat means we're going to dump responsibility on you. You're responsible for the internet, all of it, even the hurricane-affected areas. So I know it's a tough day. You probably didn't want this win, but I think you're up to it. We're just going to route all the calls your direction. And if you could just take care of all of them, that would help us out a lot. Congratulations, Denise. Thank you very much. All right, trying to get my camera working. It's not. Spoiler alert. Okay, let's give it some time to wake up. It's not going to work. I need to stand up and fix it. The problem is it's Friday, and I don't have another camera to go to. Let's see. Let's try this one. Let's do this. Let's get ready here. We've got birthday things and things to go to eventually. Let's turn that off. Let's turn that off. Ready here. Let's pretend. Let's pretend we're going to court. And I think that's the right one. I don't even know. Oh my goodness. Let's see. Yep, we're good. Okay. We're all good. Okay, we're gonna be in court, and you guys just don't look. It's one of those "don't look, Ethel" moments. If you guys got that reference, that was probably not appropriate. DVE input 4. Okay, I'm hiding. All right, let's see. We have, I'm waiting for my camera to load, which it's still not doing. Buffer. We have Shaylin, Donna E., Sheena, and Kathy Trout celebrating their birthdays today. So maybe if you could join with me in singing while we wait for court to begin. Let's tie that, shall we? Upstream key 1 is going to be tied. There we go. All right, so we're going to sing Happy Birthday. So let's, if you will warm up with me, if you will. Ready? La 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 la. There we go. Wherever you are, stand up, sing to the top of your lungs, blend your voice with your neighbors, deep breath, project to the back of the room. We're going to celebrate birthdays for Shaylin, Donna E, Sheena, and Kathy Trout. Here we go. Dancers at the ready. Go. Happy birthday to you. Happy birthday to you. Happy birthday, Shaylin, Donna E, Sheena, and Kathy Trout. Happy birthday to you. Shaylin, Donna E, Sheena, Kathy Trout. I realize today's a crazy day. We've got hurricane recovery. Some places we don't even know what's happened with the hurricane. It's just been that bad. But your birthday was planned before this hurricane even came on the horizon. So you have, I don't know, I was going to say squatters' rights. you were here first. You were here first. Happy birthday. Hopefully we can make your day a little bit specialer. Thank you for being here. I realize there are a million places you could be and a million people you could be with. But you've chosen to be here with us. Thank you, thank you. Oh, Selena K. We need to sing Selena K too. So, oh, no. 7-year wedding. I almost sang happy birthday to you, Selena, which wouldn't be appropriate on a wedding anniversary. There's got to be a song for a wedding anniversary. Selena, happy wedding anniversary to you and yours. Sinbad, thank you very much. It would have been my dad's 99th birthday. I'll always remember him wishing a happy birthday in heaven. That is awesome, Sinbad. Thank you very much for sharing that as well. All right. Linda, we might have to say it today. We might have to say it. Just saying. All right. For those who are celebrating their birthday, I almost forgot. Don't miss out this part. Free pancakes. It's your special day. You can go to some establishments, corporate establishments, and announce your birthday. Sometimes you have to verify it, but by doing so, you become eligible for a free stack of pancakes on your birthday. So please, as you get your drumsticks ready for air drums, go get your free stack of pancakes. IHOP, Denny's, Waffle House, McDonald's, Village Inn. Can you think of any others? Wherever it is. Here we go. Big drums. Beautiful drum solo, Jennifer. I heard your snare. It was amazing. My camera's still not working, which means I have to unplug it and drag it over here. Looks like this. This is my camera over there in the corner. Oh, that's funny. It still has the plastic on the display screen on front, with the little tab, meaning pull this off. That little red tab. Wait for... Ooh, we've got a small picture. That's no good. We need a big picture. Power it off. And we'll try turning it off and on again, see if that helps. It's coming back on. Oh, look at this. Look at this. Not a sponsor. I also don't want to show the bookcase because it's not tidy right now. There we go. Okay, we're good. We have a camera. No. I literally just unplugged it, which removes all the settings. I unplugged it as I was putting it back up. We're gonna go through this cycle again.
Have them send someone with more experience.
For those asking about me, I am fine. Honestly, we are on the side of North Carolina that might get an
If
inch
they
of,
didn't, I would lose my mind.
might get an inch of rain. An inch of rain for us is like a Tuesday.
When are we going to break for lunch, Judge?
All right, we have camera, we have power. Look at that. It's beautiful.
Is that correct?
All right, we might need someone with a little more experience for sure. Okay, we are getting set to get started. I think we're like perfect timing. Let's see. On air ready, super source ready to cut. There we go. I think we're waiting for the defendant to walk into court right now. We are. We are watching the Ohio versus Madden trial. Finally caught up after several days of watching behind the times. Everyone is going to talk slower today than previous days, just for the record, just so you know. Have your expectations set in that area. While this is starting, let's do a little catch-up. Lunch Lady says, what's this trial about? I haven't had a chance to catch up. Well, here's the deal. Mr. Madden, Toby Madden, is accused of stabbing his girlfriend, who he had a longtime girlfriend, 27 years they were together, stabbing her to death. 55 times was the stabbing. Yeah, a lot. We're in court here because he's pled not guilty. His story is, or his defense is, that it was the gas men, the three guys from the city that came to check the gas to make sure they could turn it on in the house that they were renovating. They showed up, said, no, there's a problem with your heater. You'll have to fix that. They left. Those gas men, I think 4 of them, a supervisor and 3 crew, all said she was there, but she was alive when we left. And he's saying, no, it was them. There's a lot of evidence that doesn't look good on him, like DNA. But of course, they were together, so there's a reason. And he was doing CPR on her when the police arrived. So that could explain some DNA. But he had changed clothes, and there was bloody clothes in the basement. That's not good. There's some knives that have some DNA or some blood on them. And then there's the whole issue that Monday, right when trial was beginning, as they were now, talking about some of the, people in court, right before the jury comes in, they're doing a little pre-trial work. Defendant stands up and basically yells out a confession in the presence of the judge, the prosecutors, the defense, the gallery, everybody but the jury. It's my fault, or something to that effect. I'm responsible. I'm sorry. We had an argument. I don't want you to hate me. All this stuff. That becomes evidence. And so it was incorporated into the opening statement. The prosecutor's like, usually I'd stand up and sort of lay out the case and what you're going to see. But just so you know, 30 minutes ago, he confessed. So there's that. It's a gruesome attack. It was horrific. The daughters testified against the dad. She's 26. She's also had an outburst in court and called him a band-aid, bastard. I can't remember. So a B word. And the defendant himself has had many outbursts where he's either crying or talking or yelling, or there he is right there. There's Mr. Madden right now. He was upset the other day, 2 days ago, when he came into court because he hadn't had a shower in 4 days. And this court thing was really messing with his schedule. So a bar steward, he called him a bar steward. That's right, a bar steward. Thank you. I don't know why that slipped my mind. A basket stealer. Yeah. Anyway, he looks like he's trimmed up his goatee. So the shower and shave thing looks like it happened. Little background on him. He's got some priors, including like 300 grams of meth in his suitcase or something. He also has a prior. I think there's a prior assault of some sort on his record, and And he, first of all, he doesn't want to be here, but he doesn't want to have a lawyer. He's tried twice to be pro se, and the judge won't let him. So the relationship between him and his lawyer, who he's talking to right now, is a bit strained. And at times he just wants to interact directly with the judge, which he has been admonished over and told that can't happen. Now, where are we in the case? Yesterday, the state said, we're done. And the jury hasn't heard it yet. So the first thing we should hear this morning is the state say that they're resting their case in chief. That brings us to the defense's side. And, of course, there might be a colloquy about him, whether he testifies or not. I'm not sure how they're going to handle that. Looks like the judge is coming in, maybe the jury. But that's the judge.
Please, in for Butler County, Donald Gentleman McGuffrey presiding, is now in session.
Good morning. Back on the record in State versus Madden, CR 22-121675. And Mr. Burris, Mr. Hahn, and Detective Horton are present on behalf of the state of Ohio. And Mr. Madden appears with counsel, Mr. Wilder. The jurors are not in the room. Before we bring the jury in the room, is there anything that the state would like to put on the record?
Good morning, Your Honor, and I don't believe so. Thank you.
Okay, anything on behalf of the defense at this time?
Yes, Judge. This morning, we had a couple witnesses who were going to testify. One of them is Mr. Madden's brother, Tim, who's in the courtroom today. I plan to call him, but it's my understanding that my client does not want that done, so I would want to put that on the record.
Very well.
He does not want that to occur.
Very well. Anything else you'd like to put on the record?
We've had a fight
We also
this
had
morning.
a neighbor, Tamara Dewar. She was here Monday and Thursday. I thought she was going to be back here today to testify. She does not appear to be here at this point. However, given some of the testimony by other neighbors and the reason she was going to be called, I think we have got into evidence, so I'm not requesting that her appearance be found at this time.
All right. We will be letting the state of Ohio rest, and would you like to present a case after the state has rested?
We also have a
Your Honor, with those things that I just mentioned, the only other potential witness would have been Mr. Madden himself. So I don't know if this is the time to discuss that or not.
Colloquy.
His decision whether to testify or not. So given that he doesn't want his brother and there's no other witnesses ready and available, Mr. Madden is the only remaining one. So I think we need that colloquy now.
All right. All right, Mr. Madden, you do have the right to testify in this trial. It is your constitutional right. Do you wish to exercise that right today?
Oh, ma'am.
All right, then we will let the state rest its case, and we will be prepared for closing arguments. Let's go ahead and take a seat, because I think we're going to have some other business then to take up, so we can move a little bit more smoothly through the process. Okay, so we'll be ready for closing arguments, and we talked about our jury instructions. I did see that you filed a proposed jury instruction. Mr. Wilder, I have reviewed your motion. Is there anything else you'd like to put on the record in support of your request?
No, Judge. Everything I would say right now is contained within my motion. It's filed as record, so I would stand on the motion and incorporate those arguments in the paper as if stated here this morning. So I would stand on my motion.
And does the state wish to respond to the request for the jury instruction?
So, Your Honor, voluntary manslaughter, I read as being defined as no person, while under the influence of sudden passion or in a sudden fit of rage, either of which is brought on by serious provocation occasioned by the victim, that is reasonably sufficient to incite the person into using deadly force, shall knowingly cause the death of another or the unlawful termination of another's pregnancy. Obviously, that part doesn't apply. While I certainly will probably, there'll probably be some arguments that stabbing somebody 55 times certainly seems to be a sudden fit of rage or sudden passion, I do not believe that there's any evidence that would suggest, or any evidence that we heard from this witness stand that says that was brought on by the victim, Rochelle Bruce. Also at this point, because that part is lacking, I would object to the instruction.
Okay, well, the court has reviewed the statute as well as State versus Amison, which is a 12th District Court of Appeals case 2021 Ohio 1537. And in that case, the trial court declined to give an instruction on voluntary manslaughter in a murder case, and the 12th District Court of Appeals upheld the trial court's decision. The court referenced State versus Gray, also out of the 12th District, 2011, Ohio 666 in its decision, and indicated that for provocation to be sufficient, it must be sufficient to arouse the passions of an ordinary person beyond the power of his or her control. And I quote from the Gray case that was referenced in Amison: if insufficient evidence of provocation is presented so that no reasonable jury would decide that an actor was reasonably provoked by the victim, the trial judge must, as a matter of law, refuse to give a voluntary manslaughter instruction. And the court has carefully reviewed the evidence that the defendant believes was proffered that would support the instruction. However, in this court's mind, the court does not believe there is sufficient evidence for it to give the voluntary manslaughter instruction. So it is respectfully going to deny that request. Anything else with the jury instructions that we have gone over that the court proposed previously?
I think all of them are standard issued OJI instructions. I would just ask for a new copy of what it is. It's also going to be ready to the jury.
Okay. Any other requests or additions, Mr. Wilder?
Other than what we requested, I understand the court's ruling. I didn't have any other issue with the instructions as given to me.
Okay. All right. I'm going to use the same copy that I gave to you, but we will be printing them out for the jurors. If we make corrections during the course of that, I'll print up a new copy and make sure everybody has those before they go back to the jury.
I do. Your Honor, when I read through the draft, I
Yes.
think the pronouns were wrong in
Okay,
some of the parts.
okay.
I think it said her, it should say him.
Okay. I will hopefully catch those as I read them and make the changes for the final copy that I'll provide to you and before it goes back to the jury.
Heaps, congratulations.
If I may,
9 months.
I did note that Mr. Madden's decision, he just put on the record to not testify. Obviously, the language of him not testifying needs to be in the instruction.
That is.
Oh, because we had it in that he would.
Defendant
Yes,
does
sir.
testify, so obviously there needs to be language about him not testifying and accepting the standard language of not
Yes, sir.
use that against. So.
All right. Thank you for that.
Your Honor, if I could just add one more thing. I've asked him multiple times to paint us some information that would show how this all started, and he's refused over a period of months. He's told me to my face that he's not going to subpoena the information, and that if I try, he said later on, you're just going to have to file an appeal. But I'm not, for the same reason that the neighbor that was next door to us, the mayor, the one who robbed the bank, there was on record, that she was saying that me and Rochelle both were great neighbors, and I don't look like somebody that would be a murderer. And, she was happy to have us, and she let me use the phone all these different times to call while we still were living. But he thought that wasn't sufficient enough evidence for the jury to hear, and I thought it was. He said, but if you try to bring that forth, I'm going to make sure that she shuts it down. Why would he have you shut that down? I don't understand, but listen, you've made a ruling. There's plenty of things that I thought that needed to come out. For example, when I asked him to ask the detective, this someone right here, when he ran down the hallway after I was beat up on March the 27th and taken down 2 hallways, dragged out of my shoes down to the bottom of the basement inside a cell. You could hear me screaming out. Why did he leave this courtroom and run down 2 hallways? Why did he come up to my face? What did he say to me? What? He goes, I don't. And then, when I said, hey, ask him if he knows Rochelle's niece who works at the front desk at the Hamilton Police Department in the same building that he works at. I just asked him if how well he knows her. He refused to do that. So there's so many things that I thought that I just wanted to put on the record. And I
You sure you don't want to testify, sir?
And that's all I have to say right now.
Is there anything else, Mr. Wilder?
Judge, I'm not going to respond to the allegations, because if I were to do that, I would be breaking attorney-client privilege, and I'm not going to do that at this point. I'm prepared to argue his case as best I can based on the limited discussion we've had about the case. Despite my many efforts and meetings with him, not having a lot of information about the situation that occurred has limited me, but I'll just leave it at that.
Well, one other thing. You know that on March the 27th, about near 9 a.m. 2024, I was brought in here in the afternoon, probably sometime. Most of the time I had hearings that were in the afternoon, 3:15, 1:45. Times that my family didn't even know that because times weren't being logged on the computer when I was having court. So nobody could be here. I was brought up with no other inmates. I was always and woken up out of my sleep, said, "Hey, you got a court date today."
3 in the afternoon. Woken up out
having hearings without me there. But I was in the jury box, and I said, "Hey, they were wanting to have a proceeding with me while I was inside there." And I said, I protested. I said, "Hey, listen, I'd like to be at the desk, so that I can go on record. Because if at any time that there's been a proceeding or a hearing here, if you haven't heard my voice, then you can sure be 100% know for a fact that I wasn't there. And being that I was not allowed to come over and sit at the desk, listen, and I protested. I didn't want him as an attorney. You know that I didn't want him as an attorney. And I told you all that. I don't want him as an attorney. And for that reason, he said, get him. And I had his shoes beaten off of me all the way down the hallway, down 2 hallways, down to the elevator. And this man right here gets up for some reason and comes down the hallway.
I'm going to stop you, Mr. Madden.
And ask him what he said to him.
We've talked about some of this before.
Okay.
I've got your jury is waiting, and I don't want to keep them waiting. Okay?
Yes, ma'am.
So if if everybody's prepared to go forward, we'll go on with the closing arguments, and I'll have the jury instructions modified while we're doing that, and have them passed out to you before they're read to the jurors. But we will change the language of that.
On the record, I did ask for that preservation of that footage. Of the footage when I was beat up at the jail too. So, but none of those things. Multiple. But here we are.
And we're going to go ahead and bring in the jurors. Okay. Thank you.
We will bring the jury.
So, if you are new to this case, this is what we have. This is what we have. That you live here now. We're almost over. It's almost over. I don't think that's going to be his last outburst in court. Just for the record, he had zero reason to even speak to the judge at this point in the trial. Zero. He'd already said he does not want to testify, and at that point, he's pretty much done talking to the judge. But you can see there is Lady Justice 7K. I've been looking for the statue that's behind the judge. It's huge. Is it like the 56-inch version one? Anyway, I can't afford 7K. I'm not going to pay 7K for a statue. I was thinking maybe $70. Maybe I'll get the styrofoam version instead of the cast bronze. All right. If he tries to talk to the jury, he will be shut down in a hurry. What's this, a vacuum?
Good morning, ladies and gentlemen. Does anyone have any violations of the court's recess instructions to report?
Just from the defendant.
Okay. All right, we left off with the last witness being presented by the state of Ohio. How does the state of Ohio wish to proceed this morning?
Yes, Your Honor, at this point, with the admission of all the state's exhibits, the state has no other witnesses to present to the ladies and gentlemen of the jury, and the state will rest.
Very well. And Mr. Wilder, does the defendant wish to present a case?
No, Your Honor. Thank you.
Very well. Okay, so ladies and gentlemen, you have now heard all of the witnesses, and you will receive all of the exhibits into evidence, and it's time for closing arguments. So please keep in mind that the closing arguments are not evidence. They are designed to assist you, and they are the attorney's views of how they think the evidence proves or does not prove the charges. So they are designed to assist you, but they are not evidence. Now, in accordance with the rules, because the state of Ohio has the burden of proof, the prosecution will go first with its closing argument, and after they have concluded, the defense will have the opportunity to present its closing argument, and then because of that burden of proof, the prosecution has the burden to give you final words in a rebuttal closing argument. So that is how we will proceed with this portion of the trial, and whenever the state is prepared to go forward, you may do so.
We move that.
Sure.
This one's almost over. It's been very quick. Please use the microphone on the podium.
Yes, sir. Yes, sir. What do you have numbers you want?
Do I need to go?
Selena K just gifted 5 memberships. Thank you, Selena.
May I proceed?
You may.
Morning, ladies and gentlemen. Echo there.
It's not.
I'm going to read to you Toby Madden's own words. These are the words that he spoke on Monday before you entered the courtroom, before opening statements.
Yes, this is good.
I'm responsible for what happened to her. I didn't mean it. I'm so sorry. I love you. Please don't hate me.
Yeah, that happened.
Can you put up State's Exhibit 181, please?
Is that the video?
This is what he's responsible for.
Oh. I don't see that picture.
You put up State's Exhibit 40. This is the it that he didn't mean to do. 55 times he didn't mean it. Let me take that down.
That's the defendant.
If you recall from my opening statement on Monday morning, I told you how every trial is like a puzzle, and that you receive pieces of the puzzle throughout the week. And that's what's happened this week. And you receive those pieces of the puzzle from the exhibits that have been admitted and from the witnesses that have testified. And I want to talk about those pieces that you've received all week long. I want to help put them together for you. So we know, and I'm not going to go in the same order that they came in, but I'm going to try and put this in chronological order for you. So we know from Michaela Madden and Tanya Cook that the defendant and Rochelle were together for about 25 years, or north of 25 years. That they moved around from place to place. Michaela said they moved around from place to place, and they finally moved to 1270 Parish Avenue in the city of Hamilton, Butler County, Ohio, in the early of October of 2022, and that they were renovating this home and fixing it up to live there. We also know from Michaela that they had a rocky and on-again, off-again relationship. And we know from Tanya that the defendant had been seen hitting Rochelle in the past, and that he said that he wanted to cut her head off and put her in her mom's lap. And he said it multiple times. I'm not sure that rocky is the right word for that relationship. We also know from Detective Horton that on October 10th of 2022, the defendant went to the Kroger on Route 4 in Grand Boulevard here in the city of Hamilton. And that was in the evening, and you saw the video and the still photos. He had on a gray shirt, short sleeve shirt, button-down shirt, a green vest, white shorts, and Nike Kevin Durant 8 shoes, or KD8s. And that was in the late evening around, I believe it was around 8 p.m. on October 10th. The next pieces that you got were from the City of Hamilton utility workers. You heard from the 4 of them, specifically the 3 that went into the house. We know that there was an appointment that they had at 8 a.m. on October 11th in the morning, that they showed up on time, that Rochelle let them in, and that she sat on the couch, had a hold of their large, big dog. I believe one of them said it looked like a pit bull. All the furniture was in its place. The china cabinet was upright. The entertainment center was upright. There weren't any chairs overturned. Nothing was overturned. And that they walked through the house and they saw a male sleeping in a chair in the adjacent room. They went into the basement. They did whatever it is they were doing, running their test on the gas line, and they determined that they can't turn on the gas because the furnace is broken or it hasn't been fixed yet. And they go back upstairs, and they're leaving at about 8:25. They see the male still in the chair. I think he acknowledges a "what's up" to one of them. They tell Rochelle that they can't hook up the gas because the furnace isn't working. And that one utility worker told you that she then looks to her right to the adjacent room and gives a stare or a look to the male in the chair. And then when they left there around 8:25 in the morning, she was alive, she was well, still had a hold of her dog, everything was fine in that house. And we know from Ann Mayers, who testified, that, as she did every day, as she said, she was on her porch at around 8:45 a.m. because she watches her sister's grandson with her sister walk to school at Crawford Woods Elementary, which is right down the street. After the grandson gets around the corner and heads up to the school and out of eyesight, her sister goes inside because she said her sister wasn't feeling well. So Ann sat out there, still drinking her coffee, looking at her phone. And she tells you that sometime between 9 a.m. and 10 a.m., roughly, she doesn't remember exactly, it was 2 years ago, that she hears a scream. You all heard it. She did it for you right here in the courtroom. And she said it lasted 5 to 7 seconds, and then it came from her left. And she's at 1260 Parrish Avenue. They're at 1270 Parrish Avenue on her left. But as she said, she doesn't know. There's a lot of kids in the neighborhood. There's a lot of screaming that goes on, but she heard this one from that direction, but she didn't do anything about it. She didn't call the police. Said she went inside and she ate breakfast. And from that time that she was out on her porch, she said there was no one else out there at 1270. She didn't see anyone. The utility workers had already left. And then the next thing we know is that Officer Katie Johnson arrives there around noon or 12:10 in response to a 911 call. She gets there. The defendant's inside giving CPR to a clearly deceased body. There's multiple stab wounds in the body. Officer Johnson saw that. She said the body was very pale and the intestines were protruding from the torso. She pulls the defendant off of Rochelle and takes him outside. At this point, he's got on a lime green shirt, shorts, and Reebok shoes. Officer Johnson told you at that time there is no signs of forced entry in that house. So when you look at the timing from when Ms. Mayers told you that she heard that scream, and by the time Officer Johnson gets there, the defendant had roughly 2 hours to be alone in that house with Rochelle. And you heard from numerous detectives about the scene in their investigation. And the pieces of the puzzle that they give you, when they get there, there's no forced entry. Front door jamb is fine. The back door, it does have a dent in the door, but it's got 2 deadbolts. You saw the picture of that. That door's locked, it's secure. Rochelle's lying dead in that front room with multiple stab wounds in her body. That front room is in disarray. Furniture's overturned. You saw the cabinet on the floor right next to her. There's blood everywhere, on the walls, on the floor. It smells like rubbing alcohol, and there's 2 empty bottles of rubbing alcohol in that room near her. And then in the basement, which is completely dark, if you remember, those detectives told you there's no electricity down there. They had to light that up themselves. They find the green vest, a bloody green vest. Turns out there's the bloody gray shirt down there, which, yes, they didn't get that until about 15 days later because of the Kroger video. But they don't find any white shorts or any Nike KD8s. There's a wooden board on the ground next to Rochelle's body with 2 distinct shoe prints on it. One of which is that Reebok shoes that he was wearing when the police got there. And the other one, this Detective Horton told you, as he found on the internet, is a shoe print of a Nike KD8. There's blood in the bathroom sink and on the bathroom floor. And keep in mind, he had roughly 2 hours from the time Ann heard that scream to when the police got there. They find a Swiss Army knife in Rochelle's bag. And it appears to be wet when Detective Horton finds it. Detective Trenham tells you when he examines it, it appears to be rinsed or washed. And it's got a deformed blade, a broken blade, that matches and is similar to the tears in the fabric in the green vest and the cuts in that Planet Fitness shirt that Rochelle was wearing. And you know from Detective Horton that the defendant told him, you got to find those 3 city guys. You got to find them. There's people out to get me. But there's not anybody that I know that wants to hurt Rochelle.
Lacey, we're glad you're here. Congratulations on 3 months.
And then Catherine Daly from BCI supplies you with these pieces. Rochelle's blood is on Toby Madden's green vest. Rochelle's blood is on Toby Madden's gray shirt. Rochelle's blood is in that bathroom sink. And Rochelle's DNA is down in the well of that Swiss Army knife. Down in a part where, as she said, you're not going to stick your finger down in there. It's not going to fit. And we know from Dr. Updegrove that Rochelle died from 55 stab wounds. They were on her arms, they were on her leg, they were on her torso, they were on her head, and one in the back. And he told you that there were defensive wounds on her hands and her arms, the bruising on her hands. He also told you there was a small knife that was used. And he told you that when you look at those pictures, the darker wounds or because the blood was still pumping, her heart was still pumping. And those lighter wounds, they came as the life was slipping away out of her. You put these pieces together, and I submit to you that this is what you get. You got 3 City of Hamilton utility workers that leave that house and everything is fine. Something happens at this point. It's the piece we don't have, because the only 2 in that house are the defendant and Rochelle. Maybe she says something to him about the furnace. We don't know. But he goes off. And ladies and gentlemen, there's 1 stab wound in the back. And I submit to you that that's the first one. He attacks her from behind. He stabs her in the back with a Swiss Army knife. She turns, and she tries to defend herself. And this is where the defensive wounds come in. And he keeps stabbing her over and over and over 55 times. And in this process, they're knocking over the furniture. She's trying to get away from him. She's trying to live. She's trying to survive. But she doesn't. And then he changes his clothes. He throws that vest and that gray shirt in a completely dark basement, hoping that no one will find it. He ditches those white shorts and those KD8 shoes. Don't know where. Can't find them. He had 2 hours to do it. Then he tries to clean up. He's putting that rubbing alcohol everywhere in that front room. Detective Huckey told you, distinct smell. Then he goes in the bathroom and tries to clean himself up. That blood's everywhere in the sink. Her blood that he's washing off of him, washing off of his own hands, washing off of his own arms. And then he tries to clean up that knife. He tries to get her blood off of that knife. And then after he does all of that, he has the audacity to start giving her CPR when the police arrive and try to blame it on 3 City of Hamilton utility workers. And the final piece of that puzzle is what the defendant gave you here on Monday morning that I've already told you. I'm responsible for what happened to her. He said it to his daughter, sitting in the back of the courtroom. Ladies and gentlemen, you're going to have 4 counts here to consider when you go back to deliberating. And the judge is going to instruct you on the law and what some of the terms are in those counts and what they're defined as. And I'm going to give you a shorter version of that here now. Can you turn it? Thank you. So I'm going to take these in reverse order.
No trains yet this morning on our tube tracker.
Because I think it's a more logical way to look at these. Oh my gosh, how do I, I'm sorry, give it 1 second. I think I got it.
Focus. That was a do honk from the fire truck.
Count 4, felonious assault. Knowingly cause or attempt to cause physical harm to Rochelle Broussard by means of a deadly weapon, in this case a knife, and then it occurred on October 11th, 2022 in the city of Hamilton, Butler County, Ohio. The judge is going to instruct you that knowingly means a person acts knowingly regardless of their purpose when the person is aware that their conduct will probably cause a certain result or probably be of a certain nature. When you stab somebody 55 times, it's pretty clear that that conduct is probably going to have a certain result or be of a certain nature. I don't think there's any disputing that. And in this case, he used a knife. I submit to you it's that Swiss Army knife. And clearly, as we've stated over and over and you've heard, this happened on October 11th, 2022 at 1270 Parish, the city of Hamilton, Butler County, Ohio. Count 3, felonious assault again, serious physical harm. I just read to you before what knowingly means. It's the same argument. Cause serious physical harm to Rochelle Broussard. Ladies and gentlemen, there is nothing more serious than death. That is the worst kind of serious physical harm. And again, October 11th, 2022.
That's 2 slam dunks.
Count 2, murder. Caused the death of Rochelle Broussard as a proximate result of committing the offense of felonious assault. We just went through those felonious assault counts. 55 stabs. She's killed. She's lying dead in that floor in the front room of 1270 Parish. Count 1, murder. Purposely caused the death of Rochelle Broussard, again on October 11th of 2022. The judge is going to tell you that a person acts purposely when it's his specific intention to cause a certain result. Ladies and gentlemen, there is no other result that can be intended from stabbing someone 55 times. There's no mistaking that. Clearly it killed her. It hit her internal organs. It hit her liver. Pierced her heart. Pierced her lungs.
We're starting the poll on this
That's
right now.
a certain result. You know what you're doing. So you've sat here a week and listened to all of this. You've received all the pieces of that puzzle. You put them together. It's very clear. That puzzle is the defendant, Toby Madden. Find him guilty on all 4 counts. Thank you.
Thank you, Mr. Hahn. Mr. Wilder?
Thank you.
Poor Mr. Wilder. But at the same time, he's so glad to be at this point in the case.
The first thing I want to do is thank you. We've taken 5 days away from you. Some of you may be happy that you're away from work, but we've taken you away for 5 days to consider this case. And as we can all agree, couldn't get much more serious with allegations than what we've been here all week for. Don't think that it doesn't go unnoticed that we don't see you paying attention, listening to the witnesses. Didn't appear that anyone fell asleep. We appreciate that you did that because a serious case involves serious jurors, and you were up to the task. Before I start with making my comments and arguments about the evidence, when you cause the death of someone, the state of Ohio has to determine, well, what's your level of culpability, meaning something, was it negligent, was it reckless, was it intentional, was it purpose? For example, you run a stop sign driving and you hit a pedestrian and they die. Something like that could be negligent. You're coming here to court today, you're going down the interstate 110 miles an hour. and you hit a car and somebody dies. Well, you didn't mean for that to happen, but you were certainly probably reckless. You also may have a situation where you get in a car, you see somebody, and you tell yourself, I'm going to hit that person. I'm going to run them over. Then you start to get into an intentional, purposeful act. And then the top of the top, which is not here, but you decide, I know when, where somebody's going to be, I'm going to hunt them down, and I want them to die. And that gets into something much more higher than what we're here today for. My point with this is you can't just focus on the fact that someone is dead. You have to look at their level of culpability. Because this level of culpability is in these elements. The judge will give you the instructions on this to make that determination. Toby and Rochelle, they're together 28 years. Some of you jurors may not even be 28 years old, or just a little over than that. That's how long they were together. They're together Michaela's entire life. They're both grandparents together. Their relationship, you heard from witnesses, it's up, it's down, it's hot, it's cold, it's rocky. We even heard about some physical confrontations. Not every relationship is perfect, and certainly this one was not either. You also heard evidence that Toby believed that Rochelle was cheating on him. You also know that Rochelle is trying to renovate Parish. We saw the pictures, you saw the materials, you heard from witnesses. She's trying to get what used to be apparently a drug house, people in and out. They're trying to get this together. They're trying to renovate it. And it's not something where she's doing it and she continually kicks Toby out. Toby's there almost every day. You heard evidence, you heard testimony that Toby may be involved on some level with helping this. He's there when she's trying to get the gas fixed. So I submit to you that they're both renovating this Parish Avenue. Maybe to start a different life, the new turn in the relationship, the hot and the cold, maybe now we're hitting our stride, we're back to good. Let's go to Parish and get this thing together and turn a corner. The neighbors are happy to see them. I know Miss Myers, the bank robber, she comes in, she's Toby's strange, he's a little weird.
That's the good neighbor.
But he's over there every day. She lets him come into her house, use her phone. She's thrilled to have Rochelle and Toby there because she told you what kind of people were coming in and out of that house. Finally, she has good neighbors. And when she says neighbors, she's referring to Toby and Rochelle. Back to the culpability. All right, so Toby is charged with 2 different types of murder. In Ohio, there's 2 different statutes. The first statute that you can be charged with murder is under Section A. In order to prove that, the state has to prove beyond a reasonable doubt that Mr. Madden purposefully did this. More specifically, that Toby's specific intention was to cause the death of Rochelle. That this is what he wanted. That was his specific intention. Rochelle needs to die. The second way to prove murder in Ohio, the state is charging him in a knowingly manner. It's called felony murder. And as a result of that, you have to prove the culpability. We call it the mens rea, what someone's thinking. They have to prove that he knowingly wanted it to happen. For for knowingly state has to prove beyond a reasonable doubt that Toby was aware of his conduct will probably cause a certain result or will probably be of a certain nature. That he knows what he's doing. That she needs to die. I want her to die. I'm going to do this so she's dead. Part of count 2 involves a deadly weapon. We're going to get back to that in a second. But these, I'm assuming the Swiss Army knife, the 2-3-inch tiny Swiss Army knife, I'm assuming that's what they're alleging as the murder weapon, the one with no blood on it. We'll come back to that. So, we have these two things. We have purpose, and we have knowing. Let's think about the evidence here. You didn't hear from Toby, but the state decided to not only play, but talk about what he said here in open court.
He's mad about that.
Nothing could make an attorney more nervous than when a client starts to talk, right? This is what Mr. Madden said. This is the state has put this into evidence. I'm responsible for what happened to her. I didn't mean to do it. I'm so sorry. I love you. I don't want you to hate me. I don't think any witness, law enforcement, neighbor, whoever, didn't deny. Also, Toby was hysterical. He's distraught. He's crying. He can't keep it together. The detective said he was down there for 4 or 5 hours. And he didn't see the video, but he did agree with me. Mr. Madden spends almost all that time just laying on the floor, hysterical. He's given CPR to Rochelle. State even wants you to think that he's given her CPR after she's even dead. Is it someone who purposely wants someone dead? Why would you even give CPR at the beginning if you've done it?
After changing clothes.
Why would you continue? If she's dead, that's what you want. You leave them alone. You walk out. You get in Rochelle's car out front and leave. You walk away. You run from the police. You don't sit there and continue to give CPR to someone who's dead if that's what you want. What's the point? We're going to get to that. What about the gas service guys? Hey, we come in 8, 9 o'clock, whatever time. Rochelle's got the big dog. We're there to do a job. Nothing seems unusual to us. Rochelle doesn't seem worried, upset, afraid. Heck, it sounds like Toby's asleep in the chair. No worry in the world. Is right there in the chair, maybe woke up and said, "What's up?" We don't hear from them gas workers there's any tension. I mean, I know they're not there to be Dr. Phil or somebody like that, but think about it. If you're a serviceman going in and out of people's houses, you see something wrong, you may walk out and think, something weird about that. You know, I'm here to do the gas, but in your mind, you would remember that. Because they certainly remember the dog, right? The big dog. 2 years, and they still remember that. If they just saw something unusual, they would have told us. Here's my point with that. Got Toby asleep, everything calm. Then, 2, 3 hours later, if the state police pull up 39, just so you know, only one computer's connected, so that's sometimes we. 2, 3 hours later, here's what we got. The gas guys went in there and said nothing wrong, didn't see anything wrong. She seemed fine. He was asleep. I didn't see anything on the floor. Police come in, here's what they see. Also, police pull up 40. Then they see Rochelle there, broken lamp, furniture on the floor. What do they also find? Police pull up 64. Blood on the windowsill, 67, please. Blood splatter on the wall. So we go from gas workers saying, no problems, everything seemed fine. 2 hours later, we got this. So what happened? Well, what about motive? Why would he want her dead? The state doesn't have to prove motive. They'll get up here in a minute and probably tell you that. You'll be instructed that they don't have to prove motive. It's a good thing they don't have to prove it, because guess what? What is the motive? Where is it? What did we hear? Why would he want to stab her? I mean, these people are together this long, and if you believe Miss Cook's story, that Toby Madden continually said he was going to cut her head off and put her head in the lap of Grandma, similar to something out of The Godfather. Well, if you do,
horse head.
I'll just say whatever. Why is that happening? Where's his motive to want to do that? Everything is fine, not even 2 hours before. They're working together on this house, 28 years together. They got grandkids. And remember, we go back to the mental culpability. It's not that she's dead. It's not that her death is caused. It's the mindset. Right? Because in the scenario where I run a stop sign and I run someone over and kill them, that's a homicide. Someone's dead. And then when I get in my car and I go, I know where you're going to be. You're going to be at Starbucks at 9 o'clock. I'm going to hunch down, find you, run you over. Those are both homicides. Those are both scenarios where someone is dead.
That's why I don't go to Starbucks.
The death in both of those. The problem for the state is that you've charged him with the highest level, that this is what he wanted, that Toby Madden wanted her dead. If he's continually, again, if you believe Ms. Cook, that he walks around saying, I'm going to cut her head off, put it in Mom's lap, wouldn't something have happened before 28 years? I mean, why that day? Because something happened in those few hours after those gas workers left. Something quick happened. There had to be an argument, something, because all that furniture's on the ground. Now, I am not bringing up Toby's injuries that we're going to see here in any way to try to say that he's a victim. I'm not. If the state would please pull up 82.
Yeah, let's not do a compare and contrast.
I am in no way trying to compare and contrast some of these, what appear to be maybe minor injuries on Toby that the police took. I am not trying to do that in any way. It is terrible what happened to her. But
got a pimple on his arm.
Does this tell us a story about something that may have happened? Because the state wants you to believe Toby, after 28 years renovating, we're grandparents together, October 11th is the day Rochelle needs to die. Something happened. Furniture, Toby's injuries, while minor, something's going on. We know he thinks she's cheating. Right? People told us that. His own daughter told us that. He thought she was cheating. It's hard to imagine that October 11th was the day that Toby just decided Rochelle needs to be done. And I know I've harped on it twice, and I'll harp on it a third time, because don't just look at the fact that there was a death caused. You have to look at the mental element, because the state has to prove beyond a reasonable doubt every element. They have to prove that her death was caused. Absolutely. They also have to prove his mindset. Did he act with purpose? Did he know what he was doing was going to cause her death? If the state could please pull up 149. I believe that the state's claiming that this is the murder weapon. I bet there was another knife, but it wasn't even analyzed. Toby, you didn't hear any evidence that he left or anybody else coming in or out, so this is the knife they got. And if this is first of all, I submit to you, this is not a deadly weapon, because I don't know if it could inflict the injuries that some of those are. You had officers there for over 9 hours, and they went there for 2 days. And this is it. This is the deadly weapon. But it doesn't have any blood on it. It was sent for analysis. Nothing there. If you're going to stab someone 55 times to the point where intestines are coming out, and it's deep enough to touch the heart. I know I started with the liver, and then the coroner said, well, you can get to the liver with this. But then he said something like the heart is a little different. State has to prove to you that he used a deadly weapon. This is what you've been provided. I submit to you that wasn't even used, because there's no evidence that it was. Or DNA or what is the DNA expert talked about something being down inside this Swiss Army knife, but it wasn't blood. 55 times, intestines out, and there ain't any blood on that? You got one detective who said, I went in, it was so unbearable, the smell of alcohol. Next officer said, no, I didn't smell anything at all. Did you hear any testimony that, hey, we went and got Toby from the scene, we were interviewing him, and he smelled of alcohol? Rubbing alcohol, not like liquor, booze. Who else told you that? Nobody. If you're cleaning up the crime scene, as they've claimed, where is all the evidence of this alcohol and stuff? It's not there. And you know what that also does? It proves that he didn't purposely do this, that it wasn't his specific intention. He didn't know that's the result. People who clean up crime scenes, people who leave them, do that stuff. Those are the people who want something done, and they're going to take care of it after. People who want others dead don't stick around to give CPR, and don't give it to the point where someone is dead.
Actually, that's when you're doing CPR to bring them back.
Ladies and gentlemen,
don't perform CPR
state of Ohio
on people.
Can't meet these elements. You have to stay focused on the mental element of this. She's dead. It's horrific. It should not have happened, but it did. The element you need to focus on is the mental part of this, because they want to prove to you, and they have to prove to you, that this is what he wanted. And that's simply not the case. Thank you.
Thank you, Mr. Wilder. State rebuttal.
Yes, Your Honor, thank you.
It was a good effort.
May it please this honorable court. Good morning, ladies and gentlemen. 55 stab wounds. 55 stab wounds. To the head, the arms, the hands, chest, abdomen, liver, lungs, heart. 55 stab wounds. Ladies and gentlemen, this is personal. This is personal. And again, we heard there was some cross-examination about, wasn't there a break-in, 5 days prior? This isn't some druggie coming in and doing this. This is a personal attack that happened. 55 stab wounds. Nobody else came in and did this. It was this defendant right there. Now, the city workers, they had nothing to do with this. It was this defendant. And I submit to you, ladies and gentlemen, this defendant committed purposeful conduct and knowing conduct. And why is that? What did we learn from Catherine Daly from BCI? She told you that this defendant's clothing, the vest that we saw him wearing at Kroger, the gray shirt we saw him wearing at Kroger. What did that have on it? It had Rochelle's blood from those 55 stab wounds. Her blood is on his clothing. And what did he do with it? He hid it. He put it in the basement, in the dark basement. This isn't some accident or anything like that. If he didn't mean to do something, why is he covering it up? Why is he trying to hide his clothing? Where are the shorts? 55 stab wounds. What else does this defendant do? There's nobody else that's in this house. Nobody's coming in. Nobody's getting past Rochelle. Nobody's getting past the dog, putting his clothing on, stabbing her, and then cleaning up afterwards and hiding the clothing. That's not happening. It's this defendant's conduct. What else does this defendant do? He cleans up in the bathroom. Her blood is in the bathroom sink. If you didn't mean to do something, why are you hiding your clothing? Why are you cleaning up afterwards to make it look like it didn't happen there? Why do that? It is purposeful conduct when you stab somebody 55 times. The head, the chest, the arms, the hands. What's the phrase, death by 1,000 cuts? This defendant sure tried. 55 is a lot.
That was a good line.
And Rochelle's screams were so loud. The 74-year-old bank robber that was next door on her front porch heard Rochelle screaming for her life. Obviously, you guys are the fact finders and truth seekers. You heard her testimony from this witness stand. Is it reasonable to believe that that blood-curdling scream that she heard is coming from Michaela's mother? Your reason and common sense tells you that, ladies and gentlemen. This isn't some accidental conduct by this defendant. He wanted Rochelle to die. What else did this defendant do? In his clothing, the gray vest, the gray shirt, washed up in blood. And again, The 12 of you are the fact finders and truth seekers in this case. And I'm not going to put any photos up here on the screen, but look at those stab wounds to Rochelle. Look at the cutting in the clothing of not only Rochelle, but of this defendant. Doesn't it kind of look like that knife that we just had up there, that Swiss Army knife? Doesn't it kind of look like that knife? And where did we find that knife? It wasn't laying there in the middle of the crime scene. You put it in Rochelle's purse, the book bag. If this was some accidental conduct or he didn't mean to do something, why go through all these measures, these methods, to try and hide what it is that happened, to hide the clothing, to wash up the blood, to hide the murder weapon? Why take the time to take the bloody clothing downstairs in the dark? Why? He wanted Rochelle to die on October 11th. Whatever it is that happened, was it something over, I think it was Brian Short, I believe you heard from him on Tuesday morning. He told you, I'm explaining to Rochelle what it is that's going on, what it is that happened, why we couldn't work on the gas lines. And Brian Short, from this witness stand right here, he told you, as I'm explaining this to Rochelle, he's looking right at this defendant right here, giving him the look. And you're right, Mr. Wilder is correct. I'm going to tell you, I don't have to prove what the motive is in this case. The 55 stab wounds is pretty darn personal. Something happened. "55 stab wounds. How do you not mean to do it when you have 55 stab wounds? One stab wound, maybe you could say you didn't mean to do it. Probably not, but again, maybe. But 55 to the head, the chest, the abdomen, the arms, the hands. Come on, ladies and gentlemen. That is not reasonable. It's not reasonable at all. Why give CPR? Why give chest compressions? Again, defendant is keeping up the ruse of trying to get people to believe that he's not the one that did it. Hiding the clothing, washing up the blood, putting the murder weapon back in her purse. Detective Katie Johnson told you when I get there, this woman's obviously dead. The intestines are hanging out of her body. She's pale. He's trying to keep up the ruse that he had nothing to do with this. Defendant told you from his mouth. State's Exhibit 250. You'll have a chance to play it back in the jury room. He told his own daughter, the daughter that him and Rochelle have together. This defendant said, I'm responsible for what happened to her. I'm responsible for what happened to her. What happened to her was 55 stab wounds. And that's what he's responsible for, ladies and gentlemen. Ladies and gentlemen, I do want to thank each and every one of you for your time and attention. Mr. Wilder's I'm going to say several of the same things that he said. I've been paying attention to each and every one of you. As you're seated over there, you've been paying attention, you've been taking notes, you've been listening to the testimony. Thank you for your patience with me through some of my computer issues that I had. 55 times. Each time this defendant stabbed Rochelle, she got closer to her death. As Dr. Updergrove told you through those photographs. Each stab wound brought her closer to death. She got butchered in the home that she was renovating. And I ask that you hold this defendant responsible for killing her. Thank you.
Ladies and gentlemen, I want to say that State Exhibit
Jurors, I'm going to ask you to read the jury.
State Exhibit 66 is a stick in there. And I also, if you look at the video of them questioning me down at the police station, if you look at it, they asked me, how did the blood get in the sink? I told them that there was blood on my face after I was doing CPR, and I told them that I went to the sink.
At this time.
Look at state number exhibit number 66. Ask for it back there and see. There's a stick right there. They won't. There's plenty of things they won't bring to you. Ask for it.
Taser, taser, taser.
Okay, now we're doing that. Okay, so
I hope you're not commenting.
the court is not going to tolerate. Let me go back on from there.
You're not, listen,
All right,
what you're not going to do is I'm not going to sit here and allow you to.
Thank you.
This is what you did the last time went on.
He's getting removed from the courtroom. He will, the judge did everything she could there. He's going upstairs right now.
You come running down the hall this time? You got something to say?
Okay, it's going to take us about 10 minutes to get situated for the defendant to appear remotely. I do have copies of the final instructions for counsel. We'll share those at this time. And the court will need to read an instruction to the jurors as to why he is not in the room. We're going to take that straight out of the Ohio Jury Instructions Manual. And once we are ready to go upstairs, we will proceed.
They know why he's not in the room.
Counsel wants to review that instruction. You're welcome to do so. It's 2 OJI CR 4303, and if there are any, is any discussion you'd like to have about that prior to me giving it, you're welcome to let me know. Okay, so we can go off the record. Thank you.
Thank you, Judge. Thank you.
Is that the copy?
Yes.
Okay, so let's go back and replay really quickly what just happened. I need a replay. Do I have a replay button? I do. Let's put this on DSK2. There we go. Okay, we're cut to 8. Here we go. This is the ending. This is the ending of the state's second closing, because they get 2 bites of the apple, right? They have the burden of proof. So they start, defense goes, and then they finish. This is the very end where they're asking him, find him guilty. 55 times, find him guilty. And we pick up right here.
Defendant responsible for killing her. Thank you.
Ladies and gentlemen, I want to say that State Exhibit
Jurors, I'm going to ask you to read the
State Exhibit 66 is a stick in there. And I also, if you look at the video of them questioning me down at the police station, if you look at it, they asked me, how did the blood get in the sink? I told them that there was blood on my face after I was doing CPR, and I told them that I went to the sink.
At this time.
Look at state number exhibit number 66. Ask for it back there and see. There's a stick right there. They won't. There's plenty of things they won't bring to you. Ask for it. Right?
You can get that. Okay, now we're doing that. Okay, so
I hope you're not commenting.
the court is.
What? He's talking to his lawyer. He's looking back. The lawyer has stepped behind him. Let's see what he says here.
Right?
You can get that. Okay, now we're doing that. Okay, so
I hope you're not commenting.
That comment.
So
I hope you're not commenting.
What does he say right here?
Okay, so
I hope you're not commenting.
The court is not going to tolerate. Let me go back on from there.
You're not listening.
All right,
what you're not going to do is I'm not
to
going to
the upstairs
sit here
remote location
and
and
allow
take a
you
recess.
to.
Thank you.
I'm not going to sit here and allow you.
This is what you did the last time went on.
That's what you did the last time. Can I take my box fort with me? And then he gets another jab in. Why they didn't cuff him immediately, I don't know. But
You want to come running down the hall this time?
okay, he's talking to the detective that has the hairstyle that goes straight back and the short sides. He's accused him of coming running down the hall and saying something to him. So he looks at him and he goes,
You want to come running down the hall this time? You got something to say?
Mr.
Okay, it's going to
Okay. Oh my goodness. You were right. That was not his last blow up. He got a little bit lippy here with his lawyer. Boom, 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 boom. A little bit of jaw in action going on there. Wow. It's probably not done still. We probably still have more. We're going to end the poll right now for our verdict. And I realize a couple people have told me that they accidentally voted incorrectly. It happens every time. Don't worry. We factor that in. Guilty as charged, 94%. Mixed verdict, meaning some guilty on some charges and not guilty on others, 3%. Not guilty, 2%. Hung jury, 0. This defendant wanted to be his own lawyer. He wanted to go pro se. He did not want an attorney, especially this guy, representing him. They have fought over everything. Even today at the beginning of trial, the lawyer's like, "Hey, Your Honor, I realize it's my turn for a case, our case in chief. But guess what? The defendant won't let me call his brother. I was planning on calling. I had a witness lined up. He won't let me call him." And the other lady the other witness was supposed to be here, looks like she did a no-show. I guess no subpoena. And the last person who could possibly testify is going to be the defendant. And he says, "Well, I'm not gonna talk. I'm not gonna talk." And he lied. He talked. Amber Michelle, welcome to the gallery. Thank you very much. You got something to say? What did he say to his lawyer? Let me go back. Well, we'll go back and look at this. Let's see if we can slow it down just a little bit. All right, this is what you expect. We're gonna do a live speed. We're gonna do about 75%, so we'll slow down a little bit. We'll hear it. Ask for it. Right.
Okay, so the court is not going to tolerate
something that comment.
Okay, so
I don't know. Let's clean up the sound, shall we? Let's do a little work here live. Let's say mark the PIO, run this into my, okay, and dump. Append that to my timeline. Now we're going to edit that comment for sound. Let's see if we can just take out a little bit of noise. Do some voice isolation. It's going to be a little rough, but let's play this one more time. Ready?
Right? You can get that. Okay, now right. Okay, so
oh, I need to cut it a little longer. Sorry.
Okay, now right. Okay, so the court is not going to tolerate. Okay, now right. Okay, so
comment.
So
I told you I'd comment, something like that. That's with a lot of noise taken out. It's not the cleanest. I will give my comment. Hope you like that comment. How do you like them apples? Great suggestions as far as what he said, all of them. I will get my comment. No, you're not comment. I think it ends in comment. Okay, so let's listen for I will give that comment. Let's hear this one.
Comment. I'll give that comment.
Let's see if we can change the pitch a little bit. Let's turn off lifting the soft dialogue. Let's not reduce the loud dialogue. Let's try this again.
Not commenting.
I look
you're not commenting. I hope you're not commenting. I hope you're not commenting. I hope you're not commenting.
I don't know. Crazy. Well, we do have a lot of toys for replay. I love this new system. It's designed for like instant replay for sports, but what a better court is almost like sport. I mean, they rhyme. The two go together. All right, let's see where we are. Let's go back to our source. We're still up here. Jump to the end. Go back to our cut. Okay. It's thinking here. Told it to do too many things at once. All right. Maggie Smith passed away? Oh, no. What happened? Easy oversight. He said, in my mind, he said, you're lucky I don't have a Swiss Army knife on me. She's an actress, Dame Maggie Smith, over in England, right? I'm trying to remember to put a name to the face. Just one second. She was Harry Potter, Downton Abbey. She was 89. British actress. Oscar winner. Man, that's sad. That's sad. DSN, thank you for gifting a membership. One of the national treasures. Yeah, there's nobody like her. She could be quite stern. She played that role very well. Lori, yeah, it's sad. She lived a full life and left us with absolutely. Just wonderful entertainment and performances as an actress. She was the boss nun in Sister Act. Yeah. You would know her face if you saw it. Yep. All right. As we are getting ready to have this breakover, she was Wendy in Hook, the older version of Wendy in Hook. You're right, Robin. The pictures are generally copyright. That's the tough thing. Let's see what I can do. I'll just show you this one. Does that work? That's Maggie Smith. All right, so a couple things we have. We have we're going to be on verdict watch, but before that, the closing statements are over. Let me actually remove this pin. By the way, Josh, you're doing just an absolutely amazing job with these messages, so thank you very much. You've been trained well, Josh. We have great mods that made it great for you. All right, we got a verdict yesterday in the Dolph trial. There's probably going to be a verdict in the Army wife trial today. Is that Bree something? I don't remember that one. We probably have a verdict in the MADDEN trial today. These are all trials that started this week, or except for Dolph. Yeah, Dolph started this week as well. We are up to date with the trial. Yes, so we're live. We're on break right now. After break, there's going to be some business, meaning the jury's not brought in there. They need to make sure that all the jury instructions are correct. It sounds like it's not going to be a really in-depth process to go over them. But if they are all correct, the judge will read those jury instructions to the jury will be charged, and they go out and start deliberating. 5 minutes later, after they've selected a foreman and the foreman's finished the paperwork, we're going to have a verdict. So I'm predicting verdict music today, 2 days in a row.
State versus Madden, the jurors are not present.
We're coming back.
Mr. Burris, Mr. Hahn, and Detective Horton are present on behalf of the state of Ohio, and Mr. Wilder is present on behalf of Mr. Madden.
I love that.
For the record, Mr. Madden has been taken to another location in the building. He is able to view these proceedings remotely and hear what is going on in the courtroom, and we are able to view him as well, but his voice will not be able to come through our system, so we will be able to proceed without further disruption. So I apologize to counsel and to those in the gallery for the disruption, and if there's nothing else from the state, we'll bring in the jurors and proceed.
I believe that's correct, Your Honor. Yes.
Mr. Wilder?
Nothing from the defense, thank you.
Okay, please bring in the jury.
I don't even have a defendant here. So, I don't know where his picture is. The judge is going to make a nice, hey, he's in another room. You know, don't hold that against him. But the jury heard. They were all here. The jury can't just get up and sprint out of the room. They heard pretty much that whole thing. As they're walking out, they're looking at each other like, did that just happen? That's the first real outburst that I think the jury has seen. We've got that static. There's something in the courtroom that's wireless, and it does that. It's terrible. Judy, you missed some spiciness about 20 minutes ago. Outburst from the defendant at the end of closing arguments.
Please be seated. Are there any violations of the court's recess instructions that anyone needs to report? Okay. Ladies and gentlemen, the defendant has a right to be in the courtroom at every stage of the trial unless the defendant's conduct is so disruptive that the trial cannot reasonably be conducted with the defendant's continued physical presence. The court has concluded, due to the defendant's conduct, that the trial will proceed in the defendant's absence by remote contemporaneous video as if the defendant were present. You may not consider the defendant's conduct or absence for any purpose, nor are you to consider the court's response to the conduct. The statements the defendant was making to you are not evidence. They were not made under oath or on the witness stand and may not be considered by you for any purpose. You must decide this case solely on the evidence presented. Now, ladies and gentlemen, you have heard the evidence and arguments of counsel. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law, nor apply your own idea of what the law should be. The instructions I am about to give you will be lengthy and involved. The nature of the case requires these extensive instructions of law, which will include legal concepts and definitions which may be unfamiliar to you.
Should be about 20 minutes.
Please listen carefully. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he has been charged with an offense. The fact that an indictment was filed may not be considered by you for any purpose. The defendant's plea of not guilty is a denial of all charges and puts in issue all of the essential elements of the offense. The defendant is presumed to be innocent until his guilt has been established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If after a full and impartial consideration of all the evidence, you are firmly convinced of the truth of the charge, the state has proved its case beyond a reasonable doubt. If you are not firmly convinced of the truth of the charge, you must find the defendant not guilty. What is the evidence? Evidence is all the testimony received from the witness stand and the exhibits admitted during the trial. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It also includes the exhibits admitted into evidence during the trial. Evidence may also be used to prove a fact by inference. This is referred to as circumstantial evidence. Circumstantial evidence is the proof of facts by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion of fact, which you may make but are not required to make, from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight. By way of example of circumstantial evidence, if the question of a fact in a given case is whether or not Johnny ate the cherry pie, testimony by a witness that he saw Johnny put the pie in his mouth and eat it would be direct evidence of such fact. However, if a witness testifies that he arrived in the kitchen only to see Johnny standing there with the empty pie tin in his hand and cherry pie on his face, that would be circumstantial evidence of the fact that Johnny ate the pie. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated by you as though you never heard them. You must not speculate as to why the court sustained an objection to any question or what the answer to that question might have been. You must not draw any inference from or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts and the weight of the evidence. To weigh the evidence, you must consider the credibility, that is, the believability of the witnesses. You will use the test of truthfulness, which you use in your daily lives. There are several tests of truthfulness, one of which is the bias or interest, if any, of a witness. That is, if a witness has a personal, philosophical, or financial interest in the outcome of a case, that fact can be considered in determining the weight to be given to that witness's testimony. Other tests of truthfulness, which you will consider, include the appearance of each witness upon the stand, his or her manner of testifying, the intelligence of the witness, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which he or she testified, his or her accuracy of memory, frankness or lack of it, together with all the facts and circumstances surrounding the testimony. Apply these tests and assign the weight you deem proper to the testimony of each witness. You are not required to believe the testimony of any witness simply because he or she was under an oath. You may believe or disbelieve all or part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of that issue. Rather, the final test in judging evidence should be the force and the weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness, believed by you, is sufficient to prove any fact. If there are discrepancies in a witness's testimony or between any witness's testimony and the testimony of other witnesses, this does not necessarily mean that you should disbelieve the witness. as people commonly forget facts or recollect them differently after the passage of time. You are all certainly aware that two persons who are witnesses to an event may see or hear it differently. In considering a discrepancy in a witness's testimony, you should consider whether that discrepancy concerns an important fact or a trivial one. Should you in the course of your deliberations conclude that any witness has intentionally testified falsely to a material fact, you are free to disregard all of that witness's testimony on the principle that one who testifies falsely as to one material fact may also testify falsely as to other facts. You are not required, however, in all circumstances to consider such a witness unworthy of belief. You may accept as much of the testimony of that witness as you wish to believe to be true and reject only that part which you conclude is false. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions may have been asked in which an expert witness was permitted to assume that certain facts were true and to give an opinion based upon such assumption. You must determine whether the assumed facts upon which the expert based his or her opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. If you find the state has proved beyond a reasonable doubt all of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings as to the defendant. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings as to the defendant. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to the other counts. The defendant may be found guilty or not guilty of any one or all of the offenses charged. It is not necessary that the defendant take the witness stand in his own defense. The defendant has a constitutional right not to testify, and he must not be prejudiced in any way for exercising that constitutional right. The fact that the defendant did not testify must not be discussed in your deliberations, and it must not be considered for any purpose. Now, under count 1 of the indictment, the defendant is charged with murder. And before you can find the defendant guilty of murder, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant purposely caused the death of Rochelle Broussard. Purpose to cause the death of another is an essential element of the crime of murder. A person acts purposely when it is his or her specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of Rochelle Broussard. Cause is an essential element of the offense of murder. Cause is an act which in a natural and continuous sequence directly produces the death and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. In count 1, the essential elements of the offense of murder are 1, that the defendant did, 2, purposely, 3, cause another's death, specifically that of Rochelle Broussard, and 4, in Butler County, Ohio. If you find the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of murder, your verdict must be guilty. If you find the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of murder, then you must find the defendant not guilty. Under count 2 of the indictment, the defendant is charged with murder. Before you can find the defendant guilty of murder, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant caused the death of Rochelle Broussard as a proximate result of committing the offense known as felonious assault. The court has previously defined the term of causation for you. Now, before you can find the defendant was committing the offense known as felonious assault, you must find beyond a reasonable doubt that the defendant, on or about October the 11th of 2022 in Butler County, Ohio, knowingly caused serious physical harm to Rochelle Broussard, or caused or attempted to cause physical harm to Rochelle Broussard by means of a deadly weapon. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry or acts with a conscious purpose to avoid learning the fact. Because you cannot look into the mind of another, knowledge is determined from all of the facts and circumstances and evidence. You will determine from the facts and circumstances and evidence whether there existed at the time in the mind of the defendant an awareness of the probability that his conduct would result in him causing or attempting to cause physical harm to Rochelle Broussard by means of a deadly weapon or causing serious physical harm to Rochelle Broussard. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. The concept of causation has previously been defined for you. Now, an attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. Physical harm means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specifically adapted for use as a weapon or possessed, carried, or used as a weapon. A deadly weapon is an instrument, device, or thing that has two characteristics. The first characteristic is that it is capable of inflicting or causing death. The second characteristic is in the alternative, either the instrument, device, or thing was designed or specifically adapted for use as a weapon, such as a gun, billy club, or brass knuckles, or it was possessed, carried, or used in this case as a weapon. These are questions of fact for you to decide. Serious physical harm to persons means any of the following: any harm that carries a substantial risk of death, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. In count 2, the essential elements of the offense of murder are 1, that the defendant did, 2, cause, 3, another's death, specifically that of Rochelle Broussard, 4, as a proximate result of the defendant's committing, 5, a felonious assault, and 6, in Butler County, Ohio. If you find that the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of murder, your verdict must be guilty. If you find that the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of murder, then you must find the defendant not guilty. Under count 3 of the indictment, the defendant is charged with felonious assault. Before you can find the defendant guilty of felonious assault, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant knowingly caused serious physical harm to Rochelle Broussard. The court previously defined all terms necessary for you to decide count 3. Those definitions apply here as well. In count 3, the essential elements of the offense of felonious assault are 1, that the defendant did, 2, knowingly, 3, cause, 4, serious physical harm to Rochelle Broussard, 5, in Butler County, Ohio. If you find the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of felonious assault in count 3, your verdict must be guilty. If you find the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault in count 3, then you must find the defendant not guilty. Under count 4 of the indictment, the defendant is charged with felonious assault. Before you can find the defendant guilty of felonious assault, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant knowingly caused or attempted to cause physical harm to Rochelle Broussard by means of a deadly weapon. The court previously defined all terms necessary for you to decide count 4. Those definitions apply here as well. In count 4, the essential elements of the offense of felonious assault are 1, that the defendant did, 2, knowingly, 3, cause or attempt to cause, 4, physical harm to Rochelle Broussard by means of a deadly weapon, 5, in Butler County, Ohio. If you find the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of felonious assault in count 4, your verdict must be guilty. If you find that the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault in count 4, then you must find the defendant not guilty. You may not discuss or consider the subject of punishment. Your duty is confined to the determination of the guilt or innocence of the defendant and to the determination of any additional findings that may be submitted to you. In the event you find the defendant guilty, the duty of determining punishment is placed by law upon the court. You must not be influenced by any consideration of bias, sympathy, or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence. Make your finding with intelligence and impartiality and without bias, sympathy, or prejudice so that the state of Ohio and the defendant will feel that the case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication on the court's views on the facts, you are instructed to disregard it. You will be provided with a copy of these instructions. If during your deliberations you are in doubt about a portion of the instructions, you may request clarification. The foreperson must put your question in writing, stating specifically what is requested, and that communication must be delivered to the bailiff. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to express immediately a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest opinions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. Now, you have been permitted but not required to take notes during the trial. You will recall that I instructed you prior to distributing the notepads that the decision to take notes was a purely personal one for each juror, based upon individual habit and preference. As I said at the beginning of the trial, note-taking does not make a juror necessarily a more careful auditor of the testimony or a better observer of a witness's demeanor. Obviously, the notes of the individual jurors are not in any way to be considered verbatim records of testimony. It cannot be overemphasized that an individual juror's notes are just memory aids for that particular juror. Now, our alternate jurors, you were selected to serve in the event of any misfortune to a member of the panel. It appears that everyone is well and able to continue, so fortunately your services will not be required anymore at this point, and it will not be necessary for you to serve further. You are not to discuss this case or tell anyone how you would have voted until after this jury has returned its verdict. You will be excused when I leave the bench, and I would ask you to please leave your contact information with Mr. Halcomb in the event that one of the jurors is unable to continue, because you would be called back in and would then need to serve. So again, it is important that you not discuss this case until the jurors have rendered their verdict. On behalf of the public and the parties, I wish to express my appreciation for your services in performing this most important function. Now, the first order of business in the jury room is going to be to select a foreperson, and the court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these materials and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose the status of your deliberations or the nature of your verdict to anyone else. Now, the verdict forms that I am talking about will look like this. There will be 4 of them. Each one has the case caption, and it will
like a
say,
white
"We, the
paper
jury,
from here.
being duly impaneled, find the defendant, Toby Madden," and you're instructed to check 1. Not guilty or guilty, and there's one for each of the offense. 1 for count 1 murder, 2 for count. The second verdict form is for the second count of murder. The third verdict form is for count 3 felonious assault, and the fourth form for count 4 felonious assault. And you'll see that there are 12 lines. In order to reach a verdict, each of you must sign in ink.
Each of you must sign, not just the foreperson. Wonder if then they must not poll the jurors then.
After you have reached a verdict and you've signed those forms in ink, you will knock on the door and let Mr. Halcomb know that you have reached a verdict, and then we will return you to the courtroom. Okay, at this time I'd like to invite counsel to sidebar.
So StreamYard, the tool we use for our when we do panels, when we have everyone connect from wherever they are, as well as when they for our podcast like we had last night, just sent me a really happy email saying, "Hey, we're excited to let you know we're doubling the price. We've automatically enrolled you in the $90 a month plan." Thank you, StreamYard. Thank you for giving me things that I don't need and can't use, and you're going to charge me for. It's my most expensive. Well, it's not my most expensive bill. My most expensive bill is the Live View, but the Live View at least provides something that's useful. I don't need 4K. Oh, I love the empty chair. Oh, it's tufted. Look at this chair. Okay,
Ladies and gentlemen, at this time you may now retire and begin your deliberations.
Oh, whoa! It's time to let's start the timer. Shall we? How does that look? Is it terrible? Okay, those are hundredths of a second. We'll start cropping it off as it gets over a minute. And it looks like the jury's knocking on the door saying we're done. No, just kidding. Do we take a break? Do we play the verdict music? I think this one will be fast. We're now officially in verdict watch. I've taken the toot counter off, but there's a chance we might hear some. Message there. Don't bother sitting down. Please remain
Jurors have
standing.
been excused from the courtroom. If you kindly be seated, I do want to take up another issue. We have the issue of the repeat violent offender specification, and that is obviously something that if the jurors find the defendant guilty, the court will decide if that has been proven. Is there any evidence that the state wishes to introduce in the event that the court is required to make that finding?
$137 is where it's at right now, yes.
So, Your Honor, back on January 11th of 2024, I did do a notice of intent to use a certified prior conviction as proof of the prior. I believe it was pursuant to 2941.149. So I have one exhibit.
There's a sticker.
I do have the certified prior conviction, which I'm just looking for a state's exhibit sticker.
I may have left it.
We have
Does Alan have some?
Do you have an exhibit sticker they can use?
Thank you, Your Honor.
I believe defense counsel is yes.
Yeah, Judge, I've received this in discovery and had prior notice of it, and there's no objection to that. We would stipulate to the document as presented.
Thank you.
So would the court like me to mark that? I think our next exhibit is 251, but I know this does not go back to the jury, so I don't know if we want to mark it as.
Well, let's mark it as 251, but we'll talk about how we should handle the exhibits because you're correct, Mr. Burris, that exhibit should not be before the jury. In fact, I'll just take possession of it at the bench and we'll make sure that it stays out of away from you. Yes. And I will consider this, if it's appropriate to do so, after the jury's verdict.
Yes, Your Honor.
Okay. So we do have a number of exhibits. I think we've talked about them quite a bit, but I would ask that counsel stay when we go off the record to make sure all the appropriate exhibits are going back to the jury when you've collected them and agree that those are the appropriate exhibits. If you'd provide those to Mr. Halcomb, and then Mr. Halcomb, if you take those in for the jurors. Except in anything that would be considered a weapon. If they wish to see that, they can ask Mr. Halcomb, and if it's okay with the parties, he will take that into them, stay in there while they look at it, and instruct them not to discuss anything while he's in the room. Is that okay with everybody?
Yes.
Yes, Your Honor.
Okay. Anything else that we need to take up before we recess?
I don't think so, Judge.
Okay.
No, Judge, I have my card, my number, in order to contact me when and if there is a verdict or a question is on the area. And I would ask the deputies to keep Mr. Madden. I would like to at least talk to him before he's sent away. Other than that, I have nothing else, Judge.
All right. So we'll take, you can provide that to Mr. Halcomb, and just be, all of the attorneys be ready to be available pretty readily in case there is a question or we have a verdict, so that we can proceed as efficiently as possible. Okay, so we will go ahead and go off the record.
As they go off the record, there's not going to be a whole ton to see here. Box source 3 is going to be 4. There we go. We'll keep the deliberation timer going. And we'll keep the audio on from camera 7. Is that cool? That way if something happens, we'll hear it. All right. We can now start court hopping while we're waiting very briefly. I'm not sure what we're going to have time to watch. But very briefly, we can watch. Let's see. We haven't been in Stephanie Boyd's courtroom in quite a while. Let's see if Judge Cedric Simpson is live. We have a phone call. Hello. Hold tight. That's our cleaner for the Airbnb. And it's open. There we go. Let me make sure. I think we're good. I have to make sure she got in. Hang on just one second. Let's play a little bit of music while we wait. Or actually, let's bring up the judge. Let's bring up Judge Stephanie Boyd for just a minute, and I'm going to bail on you just for a minute. We have audio. Oh, she's approached right now, I think. That's really close. So there's no audio right now. It'll come in just a moment. I'll be right back. Can you guys see that? No, you can't see it. That's because I completely messed that up. There you go. Okay, I'll be right back. Okay, I don't know why we don't have any audio from the judge's court, but
check.
I guess now we do. They're checking it. All right. I need to figure out why the cleaner's code wasn't working. Access, don't peek at these codes, guys. Cleaner. Because I didn't have the date right. Apparently I need to make it so that she can actually get in today. Now she can get in. All right. We're business as usual. Just finished watching closing arguments. Judy, is that
Consider
wild?
allowing us to have a quick reset. My client has been participating in a program called the RIM at the jail. He's been going through all sorts of classes. He has certificate AA, NA. They have informed him there's a place called Esperanza Court. Typically that's for prostitutes, right? But they accept other people. Sean did call Esperanza and they said they could interview him on Thursday. People from RIM are the people that actually referred him to that. He said if you want to read his letter today, you can, or we can just wait. But it is basically addressing how he's asking for help and whatnot.
All right, so he wants probation. He wants to apply for probation.
Yes, but we'd like to get him interviewed for Esperanza Court as soon as possible. And then depending upon it, if they think he's appropriate, then we'll just take the plea. There's going to be.
Well, let me ask you this. Is the state in agreement with allowing him to apply for probation?
Yes. They made offer for.
Now she took us back off the air again. Judge isn't happy for some reason. She seems a bit reserved. We've only seen a moment of it, but.
It's Daniel actually, but okay. Let me talk to Daniel. Thank you, Your Honor.
You're welcome.
Your Honor, how are you doing? I see we dressed. We got the memo. Thank you. We're both wearing the blue shirts. I did not wear the robe, just out of respect, because A, I'm not a judge, and B, you are. But thanks for color coordinating again. I thought it was great. Also, I do not have a purse. I apologize. I looked everywhere. I don't have one. But that's good. Is there a way to stop the spinning numbers? Yeah. But it sort of looks funny. I'll have to fix it. Because it has a circle spinning around it. Watch this. Hang on. It has a circle spinning around it like this.
Yes.
Your Honor, the plea that we have in front of you today is just 4 to do. It doesn't include the 6 silent. So.
Oh, y'all will have to just.
Okay.
Yes.
That'll work.
And I will hand it to the clerk.
Thank you.
And if you all can redo just the plea page.
Will do. Thank you.
Here you go. They're going to need to rewrite the plea.
Is that okay?
Who's here on Jose Manjares?
That would be us, Your Honor. We're all here for this one.
Just one moment. I'm so sorry.
That's about the best I can do. Circle appears every 4 seconds. I've cropped it off as much as I can. Sinbad, we're just in a big WhatsApp group, and everyone just says what they're wearing that day. Usually the judges go first. Sometimes I'll make the announcement. Like if I'm wearing my purple shirt, I like to be the one who leads off with that. Judge Simpson is always, regardless of what everyone else says, he puts in his own thing, which is usually different. Who does this defendant look like?
All right.
Tucker
so
Gott.
Where are we on this case with
Looks
discovery?
like Tucker Gott.
We're
ready to proceed, Judge.
Oh.
Do you guys know Tucker Gott?
See, I'm
He's
looking at a
YouTuber
blank page.
that flies paragliders, powered gliders.
Yes.
It's not him.
Oh no, I'm good. The mine is still a steel trap. All right. Court is calling 2019 CR 11691, State of Texas versus Jose Manjares. Could I have parties announced for the record for the state?
Case here ahead, Your Honor.
Defense?
Kelly Piddle.
And are you Mr. Monjaras?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision? And also the First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, Your Honor.
Did you understand it?
Did you understand the MTR?
Yes, Your Honor.
Are you the same Jose Monjaras who was placed on deferred adjudication in 2019 CR 11691 for the offense of evading arrest detention with a vehicle on December 9, 2021 for a period of 5 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. Violated condition number 4 in Bear County, Texas. The defendant Jose Barul Monjaras presented there failed to report to the supervision officer as directed for the months of December 2023, January, February, and March 2024 in violation condition number 4.
All right, just one moment. I'm so sorry.
Oh, sorry. Yes. Hello. Yes. Yeah. Uh-huh. Well, I got the memo, and I wore the blue one. It's the fishing shirt, yeah. Yeah, I like it, too. Yes. No, with this guy? Oh, I'd throw the book at him. I mean, but that's just me. I mean, I don't know the case. You've followed this one. Right? I know, that lawyer. Oh, man. What a hoot. That's cool. No, I do. Yeah, I like him. Yep. No, it's great. Thank you, Your Honor. Thanks. We'll see you. Bye.
All right. So, State, are you proceeding on any other allegations?
No.
Sorry, I had a call.
He hasn't
Was I not
played yet.
muted?
Oh, I am, but you're not proceeding on anything else?
Just the number 4, Your Honor.
All right. And do you waive, do you object to the waivers?
No.
All right. With regards to violation of condition number 4, how do you plead true or not true?
True, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
All right, court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. I the motion to adjudicate, continue the individual on his probation with an alternate conditions to add SATA, vascular care. Also AA, NA, I think it's 3 times a week. Also ISP gang supervision. Also a drug patch for 6 months after SATA. And then also monthly UAs for the duration of probation. And healthy relationships program.
That's the precursor
Also,
to parenting classes.
MRT.
All right, is that the agreement?
It is, Judge.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Make sure you speak up.
Okay.
All right, so why are you not doing well on probation?
Well, when I went to rehab, the time I was a month in rehab, unfortunately, my dad passed away in that time. So when I came out of rehab, I relapsed pretty bad in drugs. And that's why in December, I came, I was in Floresville and well, I went to jail. And that's the reason, just my dad passing away. And then plus me, it was hard for me having my dad passing away. Yes.
All right, so who else do you have in your family as a support system?
Well, my mom, pero the thing is that my mom, whenever my dad passed away, my mom don't know how to handle the situation too. And we have a lot of arguments between me and my mom. So my mom was kicking me out of the house several times, and I was literally living in the streets. And that's why, like, I was really confused about everything.
All right, so why didn't you contact your probation officer to let them know what was going on in your life?
She knows about it. She knows about my dad passing away. When I came out of jail on Floresville, also I tried to contact her, and then letting know that I was out of jail and trying to set a date to meet up. And I don't have no response from her. And yes, Your Honor.
Let me ask you this. You've been in my court before. What is the number one rule that I always tell people?
Communicate.
Right? Well, and the other thing I always tell people, if you have an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to court and address with me. Miss Abrams will be there, and Miss Abrams will tell me, hey, this person has an issue. There have been people who've come in here before. They've not been on docket. And guess what we do? The clerks go in the back, pull the file, and I will have the probation officer, if needed, zoom in, and we'll try to figure out what's going on to keep you on track. That's all you have to do. And I tell everybody that same thing. Now, this healthy relationships program, is that to address the issues with his mom, or who is that supposed to be addressing?
Girlfriend, mom, what?
Oh. So are you in a relationship with anyone?
No, I'm I'm single.
I mean, do you have girlfriend?
No, I'm single.
Why? All right.
No.
So then they want healthy relationships program. Do you think that will be of help to you?
If it's with my mother, yeah. I mean, if my mom gets in the program, because we having trouble having communication with each other. And like I say, she keeping me out of the house every 50 days, every month. It wasn't healthy for me. It was crazy moving all my stuff in and out.
Okay, let me ask you this. How old are you?
I'm 30. Yes, I know.
Yeah, you got to get your own place.
Yeah, yes.
You know, and I will tell you, when you're getting your own place, sometimes you can't start out with, I'm having this beautiful mansion. You have to start out small.
Yes.
I will tell you, when I started out, guess what? And my mom always tells me this, and she's upset because she didn't know. Mm-hmm. I started out with an apartment, and do you know, my apartment was a 1-bedroom apartment. And you know what furniture I had for a bed? Some of my friends in college were moving, and they had a sleeper sofa. And they're like, hey, Stephan, you want this sleeper sofa? I'm like, yeah, sure. The sleeper sofa was my bed. I didn't have a coffee table. I had a kitchen. It came with a fridge. It came with a dishwasher. I had dishes that I'd had before, but that's all I had. And to this day, my mom is upset with that. I'm like, Mom, it was fine. She's like, but I didn't know. I'm like, Mom, it was fine. Mm-hmm. But I will tell you, that was one of those old sofa couches where you pull it out. If you pull it out, you can feel everything on your back and it hurts. So I found that it was better just to sleep on it as a sofa and not pull it out. But slowly, I bought a bed. And then I discovered from buying a bed that the mattress cost more than the bed. So I had a bed frame for a while. And then I got some more money. Then I bought a mattress. So it's no shame in starting out slowly. You just deal with it.
Yes.
So it appears to me, and I may be wrong, but it appears to me that you and your mom probably should not be living together.
Yes.
Because with your drug issues, you don't need constant upheaval, you need stability. Mm-hmm. So this is what the court is going to do. Uh-oh. As previously stated, the court is finding violation of condition number 2 true. The court will deny the motion, alter and amend conditions.
So he still gets to stay out.
What is the wait time on status? All right, so it's 2 to 6 weeks, unless y'all have some place that is less time than that. And I'm assuming nobody thinks that lifetime would be appropriate.
Part of our agreement, Judge, is for him to go to SATA for the Wilson County cases to go away. So that he has currently pending.
All right.
Well, she can change that agreement.
I believe probation said that like you would be better maybe in a lockdown facility to make sure.
Okay. All right, that'll be SATA If they had a place for you in felony drug court, I would send you to felony drug court, but they're at capacity and there's a funding issue. So I always tell people, write your legislature. They need funding. So it'd be SADA, and he's going to remain in custody till transferred to SADA, and that'll be followed by aftercare. Upon release, I'm going to want sober support meetings. I'm going to ask for 120 and 120 days. Sober support meetings. I'm sorry, could you do me a favor? Could you not take her back just yet? Okay. Sober support meetings.
Rutherford had a tornado this week as well.
The reason why I'm giving you 120 so that you can get in the habit of going. A lot of people don't like it at first, but then they come to love it. All right. And this gang supervision, is there gang membership alleged to be here? Okay.
They're running out of the
All right. ISP, and that'll be gang supervision. Healthy relationship program.
Throw them in parenting classes. Judge, just throw them in. Because it could happen any day now.
MRT. And then you can either do the drug patch or you can do the UA hotline. Drug patch costs more.
But there's more freedom.
The UA hotline, that disrupts you a little bit because you're going to have to call in probably daily. And then one day you call in, they're going to tell you to do a UA and you have to come and do it. So drug patch or UA hotline.
She said it's more expensive. UA hotline, you're going to call every day. Say, go today, you got to go. So,
Okay, and
probably do the UA hotline.
How much does the drug patch cost? I think they went up a little bit.
And he has to pay for that.
I used to know the previous price, but I know they changed their prices recently.
I think the UA hotline, Judge.
yes.
Okay. Well, before you know, because I'd like for people to have all their information.
Judge is Googling drug patch costs.
$50 every 2 weeks.
Ouch.
That's 50.
50.
I think online.
Hotline, Judge, please.
All right. So it'll be the UA hotline
Costs a
until
little bit more than
further notice.
StreamYard.
And probation, I want him tested at least once a week. All right. Is there anything else that's being requested from either side? Probation, is there anything else? All right. Is there anything else you need from the court in order to be successful?
No, I just want to say thank you.
All right. You're welcome. We can go off the record. Here's the thing in this court, to be successful on probation, communication is key. Contact your probation officer if there's an issue. If you feel as though they're not addressing it, you can always come back to court.
Okay.
Look at this. Probation, off docket. That's somebody who wants to speak to me and they're not on the docket. And guess what? I'm here. I'll speak to them. Okay. And with regards to healthy relationships, this is what I tell everybody. I take it very seriously about relationships. But if you want to see if you're fit to be in a relationship, buy an orchid. You can get orchids at the local grocery stores, Walmart, everywhere. When you get that orchid, make sure you get it when the blooms are on it. And then take care of it. Once those blooms fall off, if you're able to get that same orchid to bloom again, you may be ready for a relationship. And the reason why I say that is because when you get that orchid from the store, they'll tell you put 3 ice cubes in it. I've learned you're not supposed to put ice cubes in it. You have to do your research on the orchid. And orchids can be a little bit finicky. They tell you not direct sunlight. So you don't put it in direct sunlight. Next thing you know, it's drooping. Leaves are dead. You're watering. What do you do? What am I doing wrong? You have to have patience to get those flowers to bloom. And that'll help you if you have anger management issues. That will help you with all of that. Do you understand?
Yes, Your Honor.
All right. So when you come back,
Bring your
I'll see you with an orchid, right?
Bring your orchid.
All right. Good luck to you.
Thank you.
It better be
You're
blooming.
welcome.
If your orchid's blooming, the judge will just, clear your record, expunge the whole thing.
Here you go. Thank you.
I once grew a cactus. That's about the best I could do.
You're ready? Okay, sure.
Okay, I'm hearing train whistles, but it's local. It's here in town. It's not over the. I keep wanting to hit the train toot button. I'm going to listen really quickly to Rutherford Police.
2601 EOC.
Go for minute one.
Go ahead.
Rutherford County
Rutherford
Sheriff.
County.
You deliver at this time.
They're about to have a dam break.
Yeah, I am.
Yeah.
10-4, I have quite a few pending calls for you. Let me know when you're ready.
Yes, I am.
40, did you copy? 10-4, receive.
Central EMS 2. 2, I'm in the 700 block. Yeah, go ahead and do what you got to do.
Thank you, Hendersonville PD.
It's going to be 619. It's going to be another almost 0.3 of a mile from 723 on down towards Maple Creek.
Central Medic 50's on scene at Richmond Court.
They're trying to get people out
The Bill Street.
before a
Down
dam
here Union
breaks.
Road. We get this road opened up. It was the same way from the other side.
It's not near me.
I guess they're sitting between two different sets of trees.
Copy, Park Paget.
Central.
Okay.
We'll have a call for service when prepared.
North Carolina.
Medic 1.
Rutherford Dam
Go ahead.
is about to break. It's gone over the top, I think.
Go ahead. Camel.
10-4, Sylvia Jake Sheets, 585-410-2928.
Oh, they're stuck in a shed.
Medic 1, we'll be on your way just
They have a lot of calls going on right now, so there's a lot of mixed audio. There's some people who are stuck between down trees on a road.
There's a tree on the neighbor's trailer, unknown if anyone is inside. Would like someone to check on same.
Good. Best bet probably will be 221 south of the bypass. Go ahead. Yeah, that's what I'm thinking, but we've got a tree down with a power line across our driveway. So just let us know if you need us to come help.
Yeah.
All right. Who's here on Trujillo?
Copy, we'll do.
I'll turn off the judge for a second because that's a little crazy.
DOT make it out to you? Yes, sir. If not, I'll give him a 10-4. I'll give him a call. EMS 2. All right, 10-4. I'll call him back.
He's on.
Picked them out of 256 Hollow Creek just for your documentation.
10. TSC to 2612. One victim at Island Creek. Where are you heading now? MS2 to medic 60. That makes 4 victims. Okay, go ahead. Are you guys 10-4? Yeah, we're 10-4. What's your status? 10-4, good luck, guys. We're clear, but we have 002. Okay, we'll be on 14, just advise. 10-4.
Wayne County, Haywood County, statewide call.
Yeah, go ahead.
Anybody ends up with any extra barricades, 1491.
All right.
Temple.
Okay,
I
so
copied 60.
we're just listening into
EMS2.
Rutherford County
Graham County,
Sheriff
Mitchell
in
County.
North Carolina.
Okay. I'll leave that call open then, so we can try to get back out there and check it.
10-4 means okay, means good.
I couldn't copy
Yes.
a thing you said. Back number.
10-4 we did.
Do I need to look down there and get in there and get over there and check on that vehicle?
They've got flooding. They've got trees down.
I'm talking about the intersection of Cleghorn Mill Road and Clarksville where that vehicle apparently is.
10-4, you can clear the call. I'll contact you.
Asheville, North
We should
Carolina
be
got
at it in just a few
slammed.
minutes.
Absolutely slammed. Just the town is so flooded.
Yeah.
$2620 to USC. You got it?
Oh, yeah.
Hey, we can answer 255. I've attempted to make it to the HUD low. 1050. Unable at this time.
The EOC is the Emergency Operations Center.
255, you were able to locate Hudlow?
Okay. Well, we can't get to them. They've shut down West Mountain. They won't let us through.
People are stranded. Literally.
Unable to get on the scene due to trees down.
10-4, I know it in the slip, thank you.
20, you'll have to go up 221 north and go to the high school and cut across through there. You can meet Robbie up in that way.
Yeah, 10-4 sometimes is used as an affirmative or as a yes or an okay. Message received, copy. It's sort of it's like a okay. It's a catch-all a little bit, but it's good. This is the other side of the state. I am on the east side of the state. This is on the mountains in the west, near not far from Asheville, I think. Over next to the mountains. They had a tornado here on Wednesday? Just popped up out of nowhere with little to no warning. Not terrible damage, but we'll bail on that here just a little bit. There is plenty of area. United States, North Carolina, top scanners in North Carolina. The water is overtopping the Lake Lure Dam due to Hurricane Helene flooding. Lake Lure. Josh says, the storm was devastating for so many. I'm still trying to get in touch with my grandmother who was in a county away. Verizon cell service is down. However, the road's impassable. Roads are impassable. Live in Fort Myers, says Feral Dragon, and had to receive high water rescue services last night. Oh my goodness. Let me do a quick little check. The emergency services that I normally work with after a major storm like this typically are not needed, believe it or not, are not needed immediately after the storm. It's only after some communication opens back up. It's after the cell phone towers start working again. People are able to return to see the damage because the people I work with, they focus on fixing houses and debris and physical stuff. They're not the medical side of it. Medical is the urgent one that's happening right now, where you've got people who need to be rescued and saved and stuff like that. So it's a day or two before crisis cleanup needs to step in. But I might be doing that this weekend. Do a quick check and see where we're at. Just logging into my crisis cleanup account, see if check out the maps. Okay. There are 279 people on hold right now. Oh, they promoted me to a phone team leader and a field worker. That's crazy. Luna, you need an answer to what? What was your question? I'm sorry, let me look at this. All's well with Brandy. Yes, and actually the storm took a little twist, a little turn to the right, which actually helped Brandy out because Brandy was off to the left. So she, I'm sure, got plenty of wind and rain, but not the damaging winds we saw because she was on that backside. Opposite of 10-4, there's a lot of different very specific codes, like some. I think there's like a 1089, which means insane, quite literally. I mean, that's like, hey, just heads up, the reporting party is 1089. I've heard that call come out for a family member who had made a call to the police once. We followed Brandy last night. She took us on a beach tour. She was in a, like top floor of a very sturdy apartment complex on the beach, front row seat to the Gulf, but the storm basically missed her, which is good. By missed, I mean they got plenty of rain, but not like this. Gracefully Broken Mom. No, I am not in danger right now. As a matter of fact, even the river systems that go through my area, the rivers are only about 275 miles long, so they don't extend far enough back into the state to catch the runoff from where the storm is dumping all the water. Now we will be getting like an inch of rain or something like that, but we can do that. We can get 2 inches of rain in a regular storm and be okay. This area is very capable of handling that much water. As long as we don't get 11 inches of rain, that would be very problematic. So it's further east that has all the problems right now. Let's see. Oh, Legally Blonde. Let's see. Legally Blonde. Where is the comment? I'm looking for you. Just spoke with some of TM's family. That's the defendant in this in the case that we're looking at. They said they're originally hoping for the death penalty. It's suspended in Ohio, so they'll happily settle for life in prison. Well, let's see. Let's go to 7. We do have a little bit of motion in court. Let's turn off camera 2 or 1. There we go. Just people walking around. I don't think anything's actually happening yet, but. There we go. Leave some room for the hour marker. We forgot to do a deliberation timer. How did we miss a deliberation timer on this one? Man, I can't believe I did that. I think the family might get their wish on this one. I have a hard time seeing anything happen less than guilty on all charges. I have the timer on, but I mean the poll, the deliberation timer poll. I meant poll. And of course now we've missed the less than 10 minutes option, so now I have to create it with a few more creative options. Let's go to my channel. Live. Pause this. Okay. Man, this little spinny wheel we have going on is eating up the memory on my laptop. Like everything else is really, really slow. Let's see. Quick poll. Okay, there we go. Poll is up right now. Legal Bond says, I'm not in court today, but I'm reaching out to the family to see about the movement in the court. I think they're just walking around. I didn't see bailiffs. It didn't seem, first of all, the judge isn't there. I think they're just chilling out and walking around because they can. Ding. All right. You don't see the poll? Oh, I haven't clicked the start poll button. That's why. There we go. Poll is up now on how long will the jury deliberate. I tried to type how. W and S are right next to each other. Nice. Poll should be up right now. And I see some people voting, so Red Pen's like, sure, right. I was thinking Haas, but I was trying to type how, and my finger typed Haas. Why was the detective with the hair sitting at the defense table? Because the lead detective often sits with the defense team in case he needs to be consulted during the case. Everyone's checking their phone every time I get a message. I'll turn that sound off. It was my phone as well. Legally Blonde says, I'm hoping that it's longer. Hoss is the proper term. Did I say defense? Lead investigator sits with the prosecution. I'm sorry. I make this mistake probably once a day. Now the two tables are almost right next to each other, so they do look like he's sitting very close to the prosecution. Let's see. 46 minutes of deliberation already. Yes, I said defense and meant prosecution. Thanks for catching that. I need one of those smart AI editors that just hears what you say and translates it into what you mean. The tornado warning for my area was released this morning at 8 o'clock, and it will continue until 6 p.m. today. I think it was a watch. Which one's worse, the watch or the warning? Thomas, remind me again. Amber is actually, no, Legally Blonde is not Amber. Amber is Calypson's vixen, is without power. She's one of the people who's been affected by this. Up north of me. Greeners. I'm not sure if this is a comment you're going to get roasted for or praise for, but let me do something we haven't done very often, and we'll pop into Judge Fleischer's court. Let's see. If you've not seen this court, it's wild. It's wild. We'll keep an eye on the court there in Ohio as well in the top left corner. The audio gets better. It is Zoom audio, but it will get better than this. Might skip for a bit until he comes back, though. We'll bail for just a little bit. I'll keep an eye on that. When he comes back, we'll jump to it. Is Sarah Boone's rescheduled hearing today? I heard it was today. The hearing today is to decide if the schedule holds, if they move forward with the schedule. Judge Fleischer can be sort of polarizing because he, in a very different style than Judge Stephanie Boyd, he can be a little over the top initially, like in your face, aggressive, and really puts you in your place. But his intent is the same. He just manages it differently than Stephanie Boyd does. So when the judge comes back, we'll watch him for a minute. He can be he's flamboyant. Yes, there's a bit of theatrical measure that's backed up by, and I can carry out that threat if you push me. So you're gonna like him. They moved the Boone hearing scheduled to decide the schedule because of the storm. It was supposed to be yesterday. He has a Pac-Man suit. He has some crazy clothes. It's almost like a Mad Hatter type. You just don't know what's going to happen at any time. Memeable is how I've heard it described. Laura asks this question. This is a good one. Laura, if I can click on it. What did you think of new Koberger judge opening comment? Wow, do I really like Judge Higgler right now. Now, he might do some things that will change my opinion because he's basically left himself some wiggle room to address the media and how he wants to cover it. But right now, he has taken control. He's maintained control. He's asserted his will, and it looks like he's going to get that. So we're going to see a ruling from him probably in the next day or so. I checked this morning. It hasn't come out yet. Initially, he did allow Brian Koberger to wear street clothes to that hearing. I think he might change that. But man, when he walks into the room, sits down and says, "Just want you guys to know, I'm not going to lie to you and say I'm happy to be here." It's just like, okay, this judge, first of all, he's not in a good mood. Don't get on his bad side. It was really good, Laura. We followed it here on this channel, as well as we have a clean feed over on Top Mark Media if you guys want to watch it without my commentary. The cameras are better. The audio is, oh my goodness. Do we have like a sound effect? I can tell you what the sound effect is like when I hear the audio in let's see. It sounds like this. It's heavenly. It's heavenly. It's ASMR quality. Not that we do that, but ASMR quality. The mics are just beautiful. Beautiful. We can hear everybody. Camera shots, not so good. But we'll take what we can get. We at least get better close-ups. And he did away with the restriction on the you can't zoom in on Koberger. He wiped all those out and said, hey, everyone can use the feed. We'll start with that, and we might address it later. So we'll be back with Fleischer here in just a minute as soon as he comes back from break. I don't know how long he's going to be. I like that he's calling BS. Oh, he is. Didn't get a chance to replay Koberger hearing last night since I was watching your podcast, then Runkle, and then I slept a lot. I watched the podcast. Then I talked with Thomas for a little while, just a little bit afterwards. We always do. I love it. And then I jumped over on Ryan Holial, who had, 185,000 people watching his live stream at that moment. It was nuts. It was nuts. And he had already been live streaming for close to 12 hours at that point. And he was, about to reset and keep going for another couple hours, as long as needed. Just a crazy, crazy storm. I love what he does. And he shared, actually, last night, Ryan Holial shared some of the the information about how they get the signals, where they get them from, and everything. I think I've got a better system than him for signals. He's using a bonded cellular that takes one cell phone and sometimes one Starlink and connects those together for a feed, which is cool, which is good, which will work for a small video sometimes. But in a bad storm, you need more. You need more than that. He does a great service. I'll tell you this. He makes a lot of money doing what he does, a ton of money. And he also raises a ton of money to help people in the storm area. And I think, more importantly, in a storm like that, when it is life-threatening, I think the usefulness of having that information sent out to people in a format that's not delayed, or, hey, we'll get to it at the top of the hour, or after this commercial break, I think it's worth it. I think it's a great service. I think he providing that on the ground confirmation, the feedback, all the cameras, so you can really get an idea and say, no, we're not kidding. This really is serious. I think it's great. I love what he does, and I love what he's built. And I want to take a tour of his house and his, well, not the house, but the house he uses as his studio. Yeah, crazy number of live viewers. Just while I was watching, he gained 10,000 subscribers in just a few minutes, and never once had said, hey, everyone subscribe to the channel during that time. Over 3 million views on one part of his live stream. Holy buckets. On part one. That is right up there with some massive YouTubers. And this was a live stream. I mean, the watch hours on this, unbelievable. Living in Tornado Alley, we love Ryan Hall. I like what he does. He does something that's just amazing. I'm sure old media hates a YouTuber streaming the weather instead of depending on them. You know what he did? Not only is he just taking like the weather information that's available, you can buy access to weather information. You can buy a connection. He took that, and then he says, we're also going to, have storm chasers and bring their feeds in, which are invaluable for getting on the ground updates. Then he says, and we're going to build a network of camera systems. So wherever the weather pops up, we're going to do it. He has over 30,000 cameras, live streaming cameras. Some of them he has to log in. Some he can control remotely. Some of them are just like a website you can pull up and it'll show a picture every now and then. He has 30,000 cameras in their database around the country that they can access if needed. That rivals any government connection and better than almost every single news outlet as well. Anyway, Lady Baker gave him a huge shout out yesterday. He deserves it. Let's see. I applied to volunteer for him and he wanted a reference. He called RA and RA gave me a bad review. Oh, man. Andy Hill is smarter than like 6 weather people combined. He has some great people helping him. All right. Still waiting for Judge Fleischer to come back. We're approaching the 1 hour mark on the deliberations, which means a few of you, I'm going to end the poll right now. Let me do that really quickly. Let's see. A few of you had chosen the 1 hour, only 18%. Looks like it has to happen quick if you get that one. 1 to 2 hours, 64%. 2 to 4 hours, 14%. Clean up from the storm first, only 1%. One voter chose that one. Cameras ran through Radar Omega and their Cyclone Port network. Oh, Judge is back. Here we go. Let's go to 2.
Got on the case today, but the case is a little bit old in tooth. I'm going to try to get on as soon as possible. It's an interference with public duties. I understand why you found PC, but I think I need to look at the video and see if there is an actual interference.
The only question I really had was, does stepfather want him there? Because were you able to get the rip?
Yes, Judge, we were able to give the stepdad a call. So he stated that he wants the defendant out of the house and does not want contact with him.
Mr. Bestis, come up. Hey.
Oh, here we go.
Mr. Bestis, did you hear what she said? No, I didn't. Okay, go ahead.
So we were able to get in contact with your stepdad. And he stated that he does not want contact and wants you out of the house.
You cannot go back to that location, Mr. Bestis. I don't know what to tell you. Do you have somewhere else to go? Who do you have around that can help you?
And Judge, just I understand that there was an underlying domestic violence, as far as that's what the underlying case was, but that was never filed. Is that correct?
Yes.
Okay, so
it wasn't filed, right?
The only thing that we have today was the interference. So on the interference, the complainant would be the police officer, correct? Not necessarily stepdad. If stepdad was the complainant, I think that the state would have filed. And the only reason I say that, Your Honor, is because Mr. Bestis is a disabled vet who told me that his mother is the one who actually owns the house. That might be a dispute, maybe more so between mom and stepdad, more so than Mr. Bestis when we're looking at things. If his mom is the one that owns the house, wait, Mr. Bestis, I'd like to speak for you. If his mom is the one that owns the house, and I understand that there might have been an altercation with stepdad long ago, of course, because this case is a little old and tooth, even though, like I said, I'm just not getting on it. But from a complainant standpoint, if the state had filed it, I would think that that would be a complaint to protect. But in this case, I think that it might be, because the state hasn't filed it, I would urge against having any restrictions to the home.
Are we setting him up to fail though?
Well, no, Your Honor, I think this is my thing. Had it been, as far as I'm concerned, the reason why he's here today was on a bond forfeiture, correct? Is that why he was brought back? And I just got on the case, so I'm just trying to, but that's what I was getting from the court.
So what happened was we gave him a general order bond in March of this year. He took off, we issued a warrant, they must have rearrested him, and they gave him another PR bond September 21. Okay. Mr. Bessis, you will not get another PR bond. You take off on me again, you will be stuck like Chuck in custody.
And Judge, I can explain kind of as well as far as on the bond forfeiture. I told him that the only person who can ever tell him not to show up would be somebody who's appointed on the case. He said that when he got the bond or whatnot, plenty of lawyers called him. One of the lawyers that he spoke to on the phone told him he didn't have to show up to court. I think it might have been one of those type of things to where, and I'm gonna be honest with you, I'm not fully aware of all the disabilities that Mr. Bestis faced, but he told me that he believed that he didn't have to show up, and now when he got picked up again, he was completely surprised by it. He thought that his court case was done with because he thought that there was no arrest when it came to his father or whatnot. And I had to explain to him what the nature of this case was and what that interference really meant. Even after, and I understand that you already addressed PC, that was a surprise to him. He didn't understand why he was here today.
Michael, what do you think? What's your opinion about going home?
Judge, I understand that it's kind of an old case, but it's an old case because the defendant chose to not come to court on a general order bond.
Well, no, you're right. I'm not so much concerned about the age. I'm more concerned about if he goes home or goes back to, and we don't even know if it's mom's place. We're just going on what he says. How do we really know?
I would re-urge that right here on the current charge, we have an interference. The complainant is the police officer. Anything to protect that police officer, I'm fully on board with. But anything outside of protecting that police officer, I would say would be a little bit extra, for lack of a better term.
I have one more question. Was any alcohol involved with this or any kind of drugs or anything like this? Mr. Kim?
Well, at the time, or during the call earlier, the stepdad did say that the defendant smokes marijuana and possibly another drug. that he's supposed to be on a certain type of medication, but he does not take it.
What do I do now when Dad says he don't want him there?
Well, and I would say this again, Judge, that when we're talking about as far as Dad at this point is, in my mind, inconsequential. He is not part of this case. There hasn't been, especially, I would think, had we come back on another incident that arose with Dad since then, and we're talking about that time, had it been picked up on, hey, the reason why we came out there and we got the bond forfeiture, because we realized there was a KPS out on Mr. Bessis when we came to this disturbance. Hey, I completely understand. But it was 6 months ago and we haven't had an incident. We've just had a phone call today on a person who is not a complainant to this case. And during that phone call, we found out that a person who is not a complainant, not privy to this case whatsoever, doesn't want Mr. Bessis to live in his home. But we're going for Mr. Bessis has said as far as that's his mother's home.
I understand.
And there hasn't been, and there hasn't been any type of issue going from here or from then until now, other than a phone call.
Well, I understand this was 6 months ago, but I do think it's important to note that this was today. This rip wasn't done 6 months ago. And the stepfather didn't say 6 months ago he wanted them out of the house. He said that today. So I think that speaks also to just the ongoing situation that's in that house. And if you'd like, Judge, we can call back the stepfather and attempt to get in contact with the mother who actually owns the house.
Is stepfather complaining? That's what I'm getting back to. Is stepfather complaining? Because that is so inconsequential to this case whatsoever.
Counsel, hold on. Judge, I understand the defense's position saying that it's not part of the case. It's everything to do with this case. This is a family violence case that turned into an interference with the duty of a public servant. The only reason they have probable cause to approach the defendant and to try to detain him is because of the alleged assault. The assault has everything to do with this case. It's the reason why this case exists in your court today.
I know, but they didn't file it, though.
They didn't file it.
I understand. And whatever the reason is, Judge, that's inconsequential to the fact that the state believes that the complainant should be protected in this case. And that's why we're asking for that. That's the only reason why we're asking for that, Judge.
Again, if the state wants to protect, if the state felt there was a need to protect, they should have filed it. There's no complainant here other than the police officer. When he's talking about it being inconsequential, yes, it is inconsequential beyond probable cause. Probable cause has nothing to do with protecting the complainant. We can use many factors for probable cause, and that can be completely inconsequential to who the complainant is. The only thing we have right now is a phone call on a person who is not a complainant, and that's supposed to uproot Mr. Bessis.
So are you telling me that I cannot, because he is not technically as listed, are you telling me that I can't put conditions on to protect the stepfather?
What I'm saying is that there is nothing there that, what I'm saying is when you're talking about conditions to protect the stepfather, we are usually 9 times out of 10 talking about a domestic violence issue where there has been a transaction to where, you know, based on the state's allegation and probable cause that came from a charge by the state, which was domestic violence, which tells you, Your Honor, that you need to protect that complainant. Right now, before you in this court, we do have a charge. We do have a complainant. That complainant is that police officer, and I welcome any restrictions that you would like to place on Mr. Bessis as it relates to that police officer. Anything outside the police officer, the state should have filed it. If they really felt like he needed to be protected, the state should have filed it. If they really felt like there was a case, the state should have filed it.
What you wish for?
No, they should have done it then. I'm saying if they want to do it now, then tee it up. Let's go. But they should have filed it back then.
I understand, Judge. I understand everything counsel's saying. I believe that the reason why this case wasn't filed is because at the end of the day, the complainant did say he didn't want to file charges, but he called the police that day, and it's in the offense report. You can take a look at it yourself.
That's why they didn't file the charge.
Yes.
You asked them not to.
But he stated that he showed aggressive behavior towards him that day, and there is an assault family member in here somewhere, Judge. It's just not an actual charge, but you have every right to use your authority as judge in Harris County to impose restrictions to protect the community. The 1715 factors apply here, and that's why you should protect him.
What I'm asking for, before we uproot Mr. Bessis, and I would even be fine with rolling it next week, let's find out who actually has the ownership to that house and who can say who can live in that house. Period, point blank. I'm getting on the case right now, old and tooth, and we're talking about the state reminding us what county it's in.
What is your position? What is your position?
My position.
If I say no contact with stepfather, though?
If you
let him go back to the house, but no contact with stepfather.
I'm completely fine with that. I'm completely fine with that. No contact with stepfather whatsoever.
Let's do that.
How is that possible, Judge? How is he going to?
He's gonna have to go to another part of the house. So do this. Let your complaining witness know. Call him back now and say, look, the judge, because he has nowhere else to go, is letting him go to the house. However, he orders no contact. The first instance we get word that you have contact with stepdad, I'm going to put you in jail.
The only issue I have here with that, Judge, is I believe if you do that, we are all setting up the defendant for failure. We're setting him up for failure.
They're asking for this, though. Because he has nowhere else to go. Otherwise, I'm putting his ass on the street. I don't want to put someone on the street. It's up to them. It's up to him, Mr. Besses, to somehow work it that he's not going to have contact with it. That's not your problem. It's not my problem. We're just saying don't have contact. That's it.
Because this is something, I hate to cut you off, but this is pertinent. I know that you ripped him, but he's saying that the stepfather's in the nursing home. So I want to figure out if we can figure that part out. I know that you said that he doesn't want him there, but is he actually in the home?
At this moment today, the stepfather is in the hospital for an unrelated injury. So Germany spoke with him. I'm not sure, something unrelated to the case, but he's not in a nursing home. I think he's in a hospital.
Well, Judge, he's an 80-year-old man. He could be in the hospital for a multitude of factors. The point is, when he comes back, he's going to come back to a home with a defendant that's assaulted him before, likely. And Judge, the only other...
I get it.
Sure. I'm going back to that, Your Honor, and
I don't want him to have contact with this person. That's all I'm going to ask.
Yes, Your Honor.
Mr. Besses, two things. Don't use drugs. No illegal dope. I'm going to test you today because I want to know what is in your system.
Marijuana illegal?
Yes, it's illegal.
Is marijuana illegal?
Marijuana is still illegal in Texas. The legislature has not made it so. And with our legislature, I'm not going to get into that. It's a different discussion. But
Pickles, not politics.
Even if it was legal, I would still be ordering you not to use it while this case is open. You are not to use PCP. You are not to use any other illegal substances. I don't know. The allegation is other drugs as well. So, Mr. Besses, you've already taken off on me once and we gave you a second PR bond. That will never happen again. All I'm asking you to do not have contact with this person and don't use any illegal substances. I'm not asking you to do quantum mathematics here. You understand? Okay. If you ever have any issues, you have a junkyard dog that will fight tooth and nail for you here. There's absolutely no excuse if you ever have any issues. But I'm not going to be understanding if someone who is in their 80s and elderly and hospital bound, if you continue to have contact with them. I don't care what your excuse is. I don't care. You can go back home, but it's on you to figure out how you're going to work it, that you're not going to have contact with this person, because they're going to contact him now and let him know that you're not to have contact with this person. And if you do, okay. Thank you.
Judge, do you want to report back to court?
You can go. But if it comes back hot, then I'll call you and we'll talk, but.
Judge, how much time?
Mr. Judge Hatton, please let him know that I'm assuming he's going to test positive for THC, right? I'm going to test him again in 40 days. Let him know that if he tests positive again, likewise, it's not going to go well. Okay, he's got to stop.
We'll have a response for it. It's just me watching the video. About the next week
Have they given you off already or no?
They haven't, Your Honor, but he has no history whatsoever, so
I got it. I'm with you. Okay. Thanks. Yes. Hey.
Quick question, Judge. It's not on the docket. You placed an individual on probation for a DWI second at the beginning of this month, and you told him you would consider an occupational license. Did well on probation.
I'm gonna mute him for just a second. We've got an update. This is coming through from Roz Alerts. Does a great service on Twitter. It says, currently the National Weather Service in North Carolina has just issued a life-threatening flood emergency for Rutherford County, North Carolina, due to the imminent failure of Lake Lure Dam. Emergency evacuations have been declared, and residents downstream from the Lake Lure are being ordered to move to higher ground immediately. Authorities are urging people to take this warning seriously, as potential for catastrophic flooding is extremely high. This could be a life and death situation. So the hurricane is not quite done with us, but that is far from me. That's far from me. But there are people who are there who need to heed that and take action now.
Is to work through
back with
things
Judge
and do it.
Fleisch.
And my conversations with them, I doubt seriously if you had problems on bond, but again, I don't know that for certain. So I'll check with probation.
Please.
Thank you, Judge.
I have an off docket plea for Raul Barrera.
Okay, let's do it.
Off docket plea. Judge is like, sure, just walk in. And this judge borrowed the jacket, I think, from Hugh Hefner. Is that red velvet? I don't know.
Okay. Good morning, Mr. Barrera.
Good morning.
Mr. Barrera, you're charged with failure to identify oneself while being a fugitive from justice.
Wait for the computer.
You also have a criminal mischief. It looks like as part of the plea bargain, Omar, they're going to dismiss the mischief, right? This charge will go on your record. It's going to be there for the rest of your life. You are now facing a minimum of 90 days in jail for any new charges that you pick up. And I'm going to tell you, if you come back, life's not going to get easier for you, Mr. Barrera. Do you understand?
Yes, sir.
Self-control. All these cases are about self-control. Exercising. I'm doing my best to exercise self-control on you now. But at some point, I'm going to lose my shaisa, and it's just not going to go well on you. You understand?
Yes, sir.
Give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, the possible immigration consequences, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. Is this what you want to do?
Yes, sir.
How do you plead to the offense, sir?
Guilty.
I'll find you guilty. I'm going to sentence you to the agreement. Did he have a bond violation, Omar?
That's one we put for next Friday. I came here yesterday. There was a bond violation for past curfew. He was coming in late for work. He works for Amazon, and his shift is over like 2:30. But because he's been ordered not to drive, he doesn't have reliable transportation, and he arrived late getting back.
On probation or parole at this time?
Probation.
What are you on probation for? Where? What did they do with that?
They issued a warrant and they're going to court on November.
I'm going to tell you now that the outlying counties outside of Harris County are extremely tough. They don't get easier. Fort Bend, Brazoria, Brazos, they're more difficult, a lot more difficult than Harris County. So if you're on probation and you pick up a case, this now can be used to revoke that probation over there. Do you realize that, right?
Yes,
you pleading guilty now, they can revoke your probation. And the more criminal cases you pick up, the higher likelihood you have of that happening. You now will be required to pay court costs in this case. If you don't pay court costs, I'm going to put your butt in jail. Do you understand?
Yes, sir.
We were going to ask to see if the court would find court costs concurrent.
He has bond violations, has an open probation case, and no, he's going to be.
The open probation case is prior to these cases. The bond violation was really from getting home from work late because his wife come to come up.
How do I know? You know, you're going to be paying court costs today, Mr. Barrera. If you don't, I'm going to keep you with me. You understand? Omar, I'm not going to continually reward this fool. You know what I mean? At some point, you're going to pay the piper. And if it's having to go to prison, but people aren't going to continue to help you over and over and over, Mr. Barrera. It's now time to pay the piper, figuratively and literally. Good luck.
Hey, Judge.
I thought you were bringing
He's all smiles between the cases, but he gets so stern with the defendants.
What the hell does this mean? I mean, right. All zeros and then 28.
Adams?
This judge just recently changed his stance on allowing us to stream his content.
Hi, Day.
I'm sorry.
Wow.
I know.
To what do we owe the honor?
Dear Judge. We're here for
Treya. Happy Friday.
He's wearing a bow tie and you're wearing a tie. It's off.
I know.
That is unusual. It's usually
That's usual.
We're here for Mr. Nebedem. He's wanted
To
out of.
approach about a bond, do you want to bring them?
I have someone in the waiting room that's been waiting for a long time with that same last name.
I bet it's his family.
Adam.
It's probably his family.
I'm scared to now let people in because of all the porn bombs we get, you know? So I'm now really, really reluctant to just let anybody in because
That's alarming.
I can't believe they
we
figured
get
out.
bombed all the time.
Yeah. Oh, yeah.
And then we have like a little, just people out there and because they hear that. No. So anyways, tell me.
The judge, he's wanted out of Pennsylvania for 6 offenses. He's wanted for fraudulent document insurance.
Hold on, Dave. Hold on. He needs to hear this.
Yes, Judge.
It's only fair since it's his case that he gets to hear it, you know? You've spoken to him, Shane?
I have.
I don't know when they're going to make the announcement, but it looks like our court watcher, Legally Blonde, letting us know verdict is in after 1 hour and 20 minutes of deliberation. I'll keep the timer going just for now, but we're also going to stay with this court case just for a minute while we wait for a video to come back from court. You're seeing it live in the top left-hand corner of your screen. So as soon as something happens, we'll take that full.
Thanks, Judge. Wouldn't that be nice?
It's a dream.
Yes.
Just want to eat.
I just want to make Dave's salary. I'm sure he's making big bucks.
I don't know.
Rice and chicken, so
Yeah.
I don't know about all that.
When did y'all do this?
Melissa. She's amazing. You know?
We're gonna pause the judge just for a minute. We can continue. This is live right now, but we'll continue because I guess we have other things we need to address just briefly. Particularly, let me see, where are we at? Camera 7. Let's go here. Let's turn off camera. Let's turn off camera 1. Don't need it on there twice. Do we know when the announcement's coming officially? Anybody know? Legally Blonde, do you know when the announcement's going to be made, if there is one? Debbie's just like, just play it. Just play the music. I was hoping to get the music to coincide. We like to build up to what are pork bombs, says Julie. Yeah, not that. Groovy Cheryl appears to be quickly because room is filling, probably in about 10 more minutes. All right, we could do that. After 1 hour and 20 minutes, roughly, of deliberation time. The jury in the Toby Madden case says we have reached a verdict. We have unanimously agreed on the 4 charges he's facing. 2 charges for murder, 2 charges for felonious assault. The case has been a wild one. It's been a wild one because this defendant has introduced aspects into the court that you don't normally see in court. And those are outbursts, emotional outbursts, childish at sometimes outbursts, stubborn outbursts. Through it all, the court did proceed, kept order as best they could. At the very end, they had to remove him from the courtroom and have him watch from upstairs. He may be back in court for this. They might bring him down for the verdict, so he can personally be there for that. I think that's something that the family would want to see, especially the victim's family, which unfortunately is the defendant's family as well. This case is a case of a stabbing. 55 stab wounds with a little pocket knife is what the state says, where he stabbed allegedly his girlfriend of 27 years. And absolutely gruesome scene. He then cleaned up, changed clothes, washed hands. He had some evidence. Some was never recovered. The shoes he was wearing, the shorts he was wearing, never recovered. And then when the police did arrive, he was doing CPR at the time. She was long since dead. This was hours she'd been dead. Just a crazy trial, very gruesome, very wild. But now the jury's ready to return a verdict, and we are all here for it. It's going to be just a couple minutes before that happens. The defendant has not done himself any favors here. He tried, first of all, to be a pro se defendant throughout this case. He tried twice, at least, to represent himself. The judge would not allow him to. And throughout what we have observed this week of trial, he has had very visible and sometimes audible disagreements. Just disagreements with his own lawyer. So crazy times for sure. All right, so we're going to keep an eye on this as soon as the court comes in with motion and audio. We'll jump to that. We might go back and watch Judge Fleischer just briefly while we. Virginia's like, I just ran through the office. Oh, somebody just kicked the tripod. Easy there, easy. Can we do a poll on if he goes nuts? Okay, I will tell you. Here's my take. I'll tell you. We don't need to do a poll because I think we'll all agree. If he's in the courtroom, there will be an outburst. If he's not, there won't. That's where I put it. I don't think he's going to stand there silently and just take it. I think we're going to see that, an hour and 20 minutes. That was an easy decision for the jury. Mrs. Ari came in and offered me chocolates, but I've got a cough drop in my mouth, and I can't mix the two. Even though it's a cherry cough drop, and you can have like cherry cordials and stuff. Thank you, cameraman, for fixing that. Josh, thank you. Confirmed it. The jury has reached a verdict. I'll pin that message. Appreciate that one. We're just waiting to hear what that verdict is. I've got to get rid of this timer. This timer is killing my computer for some reason. Let's see, how do we want to do this? Let's get rid of. Oh, there was a train.
Okay, thank you. Okay, please be seated. We're back on the record. The state versus. We're back on the record in State versus Madden, CR 22121675. Mr. Burst and Mr. Hahn are present on behalf of the state of Ohio, and Mr. Wilder is present on behalf of Mr. Madden. Mr. Madden is appearing remotely
it's not there.
at another location in this building, and he is able to hear these proceedings. Okay, so I've been advised that the jury has a verdict. However, some concerns were brought to my attention during the recess that I'd like to address at this time, and I'd like to ask Sergeant Owens to please take the witness stand.
Oh, it's not over, guys. This is crazy. This is the bailiff who was transporting him. There may be new charges.
Okay, Sergeant, would you please state your name?
Sergeant Jason Owens.
And what is your occupation, sir?
I'm a sergeant with the Butler County Sheriff's Office.
And what are your present duties?
I'm the supervisor over court security.
And Sergeant, in your capacity, did you have the opportunity to go to the remote location where Mr. Madden is viewing these proceedings?
Yes, I did.
And at any point while you were present with Mr. Madden, did he make any statements that caused you concern about his return to this courtroom?
Yes, he advised his attorney that if he were not wearing restraints, that his attorney was lucky that he was currently wearing restraints, implying that he would inflict physical harm if he were not.
And did Mr. Madden advise in your presence whether he even wanted to return to this courtroom?
He advised my personnel that he did not wish to return.
All right, very well. Anything on behalf of the state?
No, thank you.
Okay, Mr. Wilder, any questions that you have?
No.
Okay, thank you, Sergeant. You may step down. In light of the sergeant's testimony, I'm going to continue to have Mr. Madden participate in the proceedings outside of this courtroom.
Yes, Your Honor.
Okay. All right. So I understand the jury has reached a verdict, and we are waiting on the state's representative.
You should be here momentarily.
Okay. Well, we'll go off the record for just a moment.
So threatening your attorney in the presence of a bailiff is probably not the best thing to do. I think that's probably on the, it's on the naughty list. I just checked. It's on the naughty list. Don't do it. He's lucky he doesn't pick up additional charges. I think the judge read that in open court just for us to understand why he will not be coming back in court and to support her decision to keep him from coming back in court. In addition, he has indicated that he does not want to be here, possibly signifying that he expects this verdict to go a certain direction, as do about 96% of us. Ivy Berlin, member for 12 months. Says, bring it on. Love hanging out with all of you. Thank you, Ivy. Appreciate that. Congratulations on the year mark. That orange courthouse looks great on you. Just waiting for the victim's advocate, who is the defendant's daughter and the victim's daughter. She's 26 years old. She testified. She was one of the first witnesses to testify in this trial. And not much love for the dad at all. As a matter of fact, at one point, when the crime scene photos were first being shown and we were getting walked through the house step by step, we went from looking at a doorknob to suddenly seeing the victim's body on the floor, uncovered, no sheet. And the victim's advocate just yelled, "You bastard!" What is it? Bar? I forget. There was a word. Bartender. Bandage. I can't remember. It starts with B and ends with bird. Oh, it was a bass turd. Like when a largemouth bass poops. I think that's what she called him. Bar stool. Anyway, she had to leave the courtroom. It was, emotions have been very high in this case, very high. And the judge has done a very good job reining it in and being patient at the same time as just moving forward, not really giving them bass poop. Threatens his own counsel. Right after closings, he just erupted and just yelled at the judge and everything else.
Okay, ladies and gentlemen, I understand that you have reached a verdict in this case. Is that correct?
Yes.
Okay, and who is our foreperson? Okay, would you please return the verdict forms to Mr. Halcomb?
Judge checking the forms to make sure they're followed properly. They all have to be signed. There has to be a verdict on each page. There are 4 pages, 2 for murder, 2 for the felonious assaults. And every juror is supposed to sign it. A little bit different process here than in other states. We're going to show you the footage of him the last time we saw the defendant as soon as this verdict is read.
Verdict form number 1. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 2. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 3. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. The verdict form is signed in ink by all 12 jurors. And finally, verdict form 4, we, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment, and the verdict form is signed in ink by all 12 jurors. Okay. Does the state of Ohio wish to have the jury polled?
No, Your Honor, thank you.
On behalf of the defendant, do you wish to have the jury polled, Mr. Wilder?
No, thank you.
Okay.
Okay,
ladies and gentlemen, I want to thank you for your attention in this matter, and I appreciate your patience with us during some of the breaks that we had to have and the concentration that you had throughout these proceedings. And on behalf of the public, I want to express my sincere appreciation for your services in performing this most important function. The judicial system, as we know it in the United States, is the finest in the world, and it is so very important in preserving the property and liberty and the rights of citizens that you are willing to agree to serve as jurors in this case. By your being here and participating, you are helping to guarantee the continued existence of law and social order in our society. So you have my thanks. And I'd also like to thank the attorneys in this matter for their professionalism. I have had you under an order that you could not speak about this case. Now that you have rendered your verdict, you are permitted, I will release you from that order. You are permitted to speak with anyone that you wish to about this case. You are not required to speak to anyone, but that will be your choice alone. In addition, I gave you restrictions about looking at things and investigating things. All of the orders that I gave you you're now released from those. And again, I appreciate your service very much. So you are discharged with the thanks of the court. I would ask that you return briefly to the jury room. Thank you.
With that verdict across the board, guilties as charged. The most he can be sentenced to is life in prison. They don't have the death penalty here. That's the daughter there in white. She was the one who testified. Very emotional moment as they got really what they were seeking, which was justice in this case. She lost her mom to this defendant, and now, although she might say it happened earlier, she's lost her dad to the system.
Jurors have been excused from the courtroom. Our next order of business is to take up the repeat violent offender specification. The court has reviewed State Exhibit 251. Is there anything else that the state of Ohio would like to put on the record with regards to that?
Yeah, I think I put on the record I did file notice of intent to use. Certified conviction is proof of the prior conviction. That was filed on January 11th, 2024. It is a felonious assault conviction. I'm sorry, aggravated assault, which I don't think that part counts. It is the felonious assault is the count 4. It's in CR 88030207, so I would ask the court to find Toby Madden to be a repeat violent offender.
Any argument on that, Mr. Wilder?
No, Judge. Thank
Okay.
you.
All right. The court has carefully reviewed the exhibit and is going to find Mr. Madden guilty of that specification and will find that he is a repeat violent offender. Okay. The next thing that I need to ask is everyone to prepare to go forward with sentencing this afternoon.
Yes, Your Honor. Thank you. Yes, Judge.
Okay. All right. Before we proceed to that, the conviction will require that Mr. Madden enroll as a violent offender pursuant to Ohio Revised Code 2903.41. And, of course, we can continue that hearing. The basis for rebutting that, the presumption that the court placed him on that registration would be that he is not the principal offender. I haven't heard any testimony that would suggest that that would be necessary. Mr. Wilder, do you oppose going forward today?
I would agree with that. No opposition to going forward. Thank you.
All right. So I'm going to give Mr. Madden some advisements, and there will be a form that I'll ask the deputies to have him sign and so that he can have a copy of it when we've concluded our hearing. Sir, you have been convicted of or pleaded guilty to a qualifying violent offender offense as defined in Ohio Revised Code Section 2903.41. If you are not sentenced to a prison term, you are required to enroll in the violent offender database personally with the sheriff of the county in which you reside 10 days after being sentenced. If you were sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after release from jail. If you are an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either 1, residing or occupying in a dwelling in Ohio for more than 3 consecutive days, or 2, residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You are required to provide to the sheriff certain information, including your full name and alias you use, your residence address, your social security number, any driver's license number or commercial driver's license number or state identification card number issued to you, information regarding the offense of which you were convicted or pleaded guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle, and a description of each vehicle, a description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you are required to re-enroll annually. You must update and or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you were initially enrolled. If you change your residence address during the 10-year enrollment period, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You are required to comply with all of the above described requirements for a period of 10 years unless your sentencing court determines otherwise. Failure to enroll or failure to verify residence at the specified times will result in criminal prosecution.
This is the formality.
So that is the form. I will go ahead and sign that at this point, and we will have Mr. Madden sign that.
That's just because it's a repeat violent offender.
Anything else on that issue from the state?
Status now. But that doesn't mean he's getting out.
Anything on behalf of the defendant?
Nothing, Judge. Thank you.
Okay. All right, then let's go ahead and discuss sentencing. First, I'd like to ask if the state of Ohio, if you believe any of these offenses are allied offenses of similar import.
The answer would be yes, Your Honor. I will, since the jury has found Mr. Madden guilty on all 4 counts, and I believe the court found him to be a repeat violent offender, which I think would be on all 4 counts, I would agree that counts 2, 3, and 4 would be allied offenses to count 1, and I'd ask that 2, 3, and 4 be merged into count 1.
Yeah, they merge into 1.
Do you wish to be heard on that issue, Mr. Wilder?
No, I would agree with that, Mark.
All right. Then the court will merge counts 2, 3, and 4 into count 1, and we will proceed with sentencing on count 1. Okay. Is there any mitigation that you'd like to offer on behalf of your client at this time, Mr. Wilder?
Judge, anticipating Mr. Madden will file an appeal in this case, which I will do for him. I have nothing further to say. I would note that I believe the RVO specification and any sentence on that would be discretionary as opposed to mandatory, but nothing further.
All right. At this time, I would ask our information technology specialist to please unmute the video feed. And Mr. Madden, if there's anything that you'd like to say on your own behalf, you're welcome to say it at this time.
Well, I would like to say something, Your Honor. I found it. I'm truly sorry to my family, to Michaela, Sherry, Ginger, Morgan, Megan, Maya, not little Megan, Maya, Morgan, and Jim, Alex, and Brandon, John, and all of her friends, Carlita, Christy, and Dawn, and I told Mr. Wilder that I'm responsible, that I committed this offense, and I told him how, and I told him what happened. I went into detail, and I told him what happened, and for some reason he chose to allow the state to perform an act of there and state that I tried to hide everything that I done, and As if I didn't do it. I never mentioned that one time that I didn't do it. I told these officers, these deputies, that I done it, and he knows that too. And for whatever reason, the mistake decided, he decided not to put up the exhibit number that I requested. He never pulled up the phone records. He never went and asked for the. Have you ever seen a murder trial where there's never been the interview produced to be seen? Not even on TV and A&B movies, but I understand why. He had an agenda, and but at this point in time,
I'm objecting to that.
I accept the court's decision.
Sustained.
But it's if there's anyone out there that wants to get to the bottom of it, and you're able to come and really see that that there's discrepancies here that aren't matching up, and there's so many that I can put you on the trail to, and the kills and bits are laying right on the floor. But when you're poor, this man I never saw for almost 4 months.
All right, Mr. Madden, I'm going to interrupt you. Okay, let's go ahead and mute it.
2 days before it was time to go to trial discussion, now he says, hey, listen, I'm going to be able to prove through logs that I showed up.
Okay.
You don't have to mute it. You don't have to mute it. I'll stop going into detail, but I'll tell you this.
I'm interested in hearing anything that you want to tell me as to why I should give you, how I should sentence you.
Well, I just want you to know this. To my family. All the years, if it would please you to know that somebody is suffering, I don't presume to know the pain that you're going through. I don't presume to know the pain that you're going through, but and I don't understand it. But I can tell you don't know the pain that I'm going through, knowing that I'm the one that caused this tragedy, and if there's any solace, there's any silver lining in knowing that when I go to bed, it's on my mind. When I wake up in the morning, it's on my mind. When I think about SeaWorld in San Diego, I think about walking on the beach in Florida, the chalet in Gatlinburg in February. I think about all the years, all the meals that we've had together, the Christmases, the Thanksgivings, the summers. These feelings, these emotions are.
All right. It appears the audio has been turned off at this time. Any objections to that, Mr. Wilder?
To the audio being
yes, sir.
No objection to that. I would, if I may.
You may.
Televised.
Yes, sir.
Without getting into specifics, obviously honoring the attorney-client privilege that I've held with Mr. Madden for 9 months, I can say that the specifics of the before, during, and after were never brought to my attention. Thank you.
Thank you. Okay, so at this time, if there are any victims' representatives that wish to address the court will hear those statements.
Wow. I believe Michaela Mann is the first one that's going to address the court. Would you like her at the podium? Would you like her at the witness stand?
The podium's fine since it's here. What would you like to tell me, ma'am?
I would just like to speak about my mom. That's good to hear. Sorry, I'm a little shaky.
Take your time.
You're fine. Okay. Ladies and gentlemen, I'm Michaela Madden. I'm Rasha Birsaw's daughter and our only child. I wanted to make this statement because I want you to know more about my mother, Rasha Birsaw. She meant so much to our family and friends. Her death has created a huge hole in our lives from which we will never recover. Rochelle, my mother, was the youngest of 4 children. She was the baby of the family. But she wasn't just a sister and a daughter. She was also an aunt, a neighbor, a friend, a member of the community, and perhaps her most important role, a mother and grandmother. Sorry. As an only child, I had the benefits of all her love and attention. She always sought to have that everything I needed. She taught me to be respectful and to be well-mannered, to work hard and help others. She dedicated her life to serve. She was a nurse, and I'm following in her footsteps and hoping to become a nurse. I mentioned that my mom was also a grandmother. I'll never forget how thrilled she was to have a granddaughter. My mom relished on every moment that she had with my daughter, Layla. After I had Layla, I noticed a change in her. My mom wanted to leave her life with Toby Madden in the past. She was focused on and excited for a better life filled with love for me and her granddaughter, Layla. This has been unimaginable for me and my family. But how can I tell you who my mom was? It's impossible to express in words who my mom was and the impact this had on our family. I will miss the big things. She loved animals, especially dogs, butterflies, and dolphins. She went out of her way to help everyone. She had no enemies. She was hilarious and smart. She had an infectious laugh. And she and I were so very close. We talked about everything. She's my best friend. The one thing that got in the way and we disagreed with was Toby Madden. He was the man that my mother set out to change. He was the man who came in and out of our lives because all he did was take. All he did was take. He was never a loving partner for her, and he was not a good dad. I mentioned that my mom always focused on others. She took care of him through thick and thin. But Toby's only interest was to put us down. All of her accomplishments. But I have made a better impact on my life than he ever will. People ask me if I'm better or if time has healed me. I will never get over losing my mother. Her life should have never ended so tragically. My mom was a healthy 50-year-old woman. She was full of life. She was ready to move on to the next chapter in her life from Toby. A chapter full of things to do, places to go, and happiness. My life will go on. I will raise my daughter, and Toby Madden will fade into the past for me and my family. There are going to be days that Toby will wonder about us, but he will never know what is going on in our lives, and he will never get the chance to see his granddaughter grow old. Even though Toby Madden ended my sweet mother's life, she will always be with me. He's not going to end our lives, but his selfish, disgusting act of taking my mother's life will end his life as well. I know she's in heaven with God and her mother and father and sister and brother who have also passed, but I would give anything to talk to her one more time, to see her be silly and laugh with my daughter, Layla. But I know I will never, because Toby took that away from us. And I just want to say thank you to the court, thank you to the judge, thank you to the police officers, detectives, my family and friends, for everything that you've done.
I'm very sorry for your loss, ma'am.
Thank you.
Is there anyone else that wishes to address the court, Mr. Burrs? Ma'am, if you could tell me your name and your relationship to the victim, please.
Hi, my name is Ginger Halcomb. I'm niece of Rochelle Purcell. Our rules have changed forever. And when I say our, I mean my Aunt Rochelle, our family, and her best friends. I know they say when you're a good Christian that you'll forgive what he did one day. But forgiveness or not, our family asks that Toby Madden gets life in prison without parole for brutally murdering our aunt. She has taken so much from us. He's a repetitive violent offender that has a track record to prove at the age of 52 that he has no chance of rehabilitation. Our local community itself is not safe with him unless he is behind bars the remainder of his life. Knowing that he doesn't have a chance to victimize our family anymore is the only way that we'll get time to process everything and start to heal. Over the course of 26 years, our family has been victims of so much violence because of his erratic, violent behavior. There are too many to even mention and not enough time to talk about. We have all been emotionally drained, having to wait 2 selfish years due to the delay tactics. The continual delays feel like it was his last selfish act to resort to torment our family further. Waking up every day to realize that your aunt is gone forever, that's not only like a second mother, but a best friend, is torture in itself. The nightmares continue to invade our lives as we try to hold each other together. We worry about what happens if he would get out. Do we have to relocate, change our names, or do we ever have to face this monster ever again? For my aunt to lose her life alone due to this vicious predator, life in prison is an easy choice to be given. At the end of the day, he still will have his life, even if it's behind bars. All I can ask of you is to please choose life in prison and to give him the maximum sentence of being a violent, repetitive offender so that our family is safe. Our family, the Halcomb family, the Broussel family, we want to thank everyone that's been a part of this case from the beginning to the end to the jury. That's all I have to say.
Thank you for your comments, Sam. I do need to let you know that this statute does not give me the authority to impose a sentence of life without parole, but I will consider your comments when I make the decisions that I have the authority to make. And I'm sorry for your loss.
The statute doesn't allow life without parole.
Anything else from the state of Ohio, Mr. Burris or Mr. Hahn?
The only other thing I would like to say, I would like to thank the City of Hamilton Police Department for their work on this case. I know I think there's maybe 3 officers that testified, but there are many more that were part of this case, and justice would not have been served today without all their efforts.
With the merger of the
The
charges,
court has
there's only one
considered the
sentence.
purposes and principles of
There will be parole.
sentencing in Revised Code Section 292911 and the seriousness and recidivism factors in Revised Code Section 292912, as well as the penalties that are statutory penalties that are associated with the offense and the specification. The court is also considering the record and the charge and the statements made at this hearing, and the court on count 1 is going to impose the mandatory sentence of an indefinite mandatory minimum term of 15 years in prison and a maximum term of life imprisonment in the Ohio Department of Rehabilitation and Correction. As to the repeat violent offender specification, the court is going to impose 10 years, and it will be consecutive to this sentence. The court is imposing the maximum of 10 years because this offense was, quite frankly, so gruesome, and the court finds that the defendant is a danger to the public, and the court relies on the Exhibit 251 and the offenses that Mr. Madden has previously been convicted of in support of those findings. The court is going to run this sentence in this case consecutive to the sentence in case number CR 22101423, and the court is running it consecutive because it believes that consecutive sentences are necessary to protect the public from future crime and to punish the offender. The court further finds that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger that he poses to the public. And the court finds that the offender's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. The court is also going to impose court costs as a part of the sentence, and the court will award 316 days of jail time credit. Are there any other findings that the state wishes for the court to make at this time?
Consecutive to his current incarceration.
So it's 15 years to life. The RVO is consecutive. I think that's by clause. Not any sentence on the RVO is consecutive at all. And what was Judge Stevens' case number?
That is a CR 22101423.
That was the conviction for meth.
I don't
300
believe
gram
there's
possession.
anything else short, I think.
Okay. Anything on behalf of the defendant.
Sure. Judge, I don't know if this is required or not. Should there be any advisement at all about PRC at all, given the sentence? May not. I was just making sure we're clear before we left.
My understanding that it does not, because of the indefinite nature of this sentence, the defendant would be subject to parole rather than post-release control. Does the state have any objection to the court's findings? Okay.
Nothing further than.
And then the final thing that I would indicate that this defendant does have a right of appeal, and he has 30 days from the date that the conviction entry is filed to file that notice of appeal.
I will file that for him, understanding that he will have a new attorney on appeal.
Yes, sir.
Thank
All right.
you, Judge.
Well, again, I thank the counsel for their professionalism, and at this time we will recess on this matter. Thank you.
So we leave this court in Ohio on that note. The sentence, he's currently incarcerated. He was found with, he was in possession of, I believe, 300 or over 300 grams of methamphetamine in his suitcase and convicted on that charge. That what the court just did is said, this new sentence that he just picked up starts when that one ends. And I don't know, they said 360 something days. So they're a year into what, a 17-year sentence, I think it was, for that possession. So so the sentence that she could do here was 15 to life. You add on the extra 10 because it's a repeat violent offender, so now it becomes 25 to life. All those are consecutive. Plus, he's got another 15 there. So we were looking at 40 something to life. 16 plus 15 plus 10. That's 41 years, roughly, to life. So 41 years minimum before he would get parole. Is my understanding on that one. And at the age of 52, that really does become a life sentence. I told you we were going to go back as soon as because we did not see the defendant during the sentencing. He was in another room. I'm going to take you back to what the last time we did see the defendant on replay here. Oops. Let me fix this. Where are we at? Need this to be on now. There we go. All right. So this is the replay of what we saw. This is the closing arguments. So the state has given their closing arguments. The defense gives their closing arguments. State gets up, gets one last bite of the apple, gives the last little pitch for ask for that. And this is the end of that. The voice you're going to hear that interrupts as this prosecutor ends is the defendant's voice.
Thank you.
Ladies and gentlemen, I want to say that State Exhibit
Jurors, I'm going to ask you to return to the
State Exhibit 66 is a stick in there. And I also, if you look at the video of them questioning me down at the police station, if you look at it, they asked me, how did the blood get in the sink? I told them that there was blood on my face after I was doing CPR, and I told them that I went to the sink.
Lawyer walks away.
Look at state number, exhibit number 66. Ask for it back there and see. There's a stick right there. They won't. There's plenty of things they won't bring to you. Ask for it. Right?
You can get there. Okay, now we're
right.
Okay, so
I know you're not commenting.
The court is not going to tolerate. Let me get back on from there.
You're not, listen,
Right.
what
We're
you're
going
not
to
going
move
to
to
do
the
is I'm not
defendant to
going to
the upstairs
sit here
remote location
and
and
allow
take a
you to.
recess. Thank you.
This is what you did the last time, went on.
This is what you did the last time. This is not new, this sort of outburst. Then after he's let out, first of all, there's one more comment here. He makes it a detective.
You want to come running down the hall this time?
You coming to run down the hall this time?
Got something to say?
Got something to say? They take him upstairs to the other room. They shackle him, and his attorney said, "Hey, I need to talk to him." His attorney's up there,
To get situated for the defendant.
and while he's up there, he says to his attorney, "You're lucky I'm in restraints," which is taken as a threat. And the bailiff's like, "Yep, that's not going to fly." So the judge, right before sentencing, read that and he basically used that incident with him threatening his attorney as saying, we're not going to allow him back. Normally the defendant would be here for sentencing. Normally the defendant's there in court. Also, the defendant at the time said, I don't want to go back to court. So it's between what the defendant's wishes were and the judge's concern for safety and security and the well-being of the court in general, you don't come back. So that's why we did not see the defendant in the courtroom for both the verdict and the sentencing. Wow. 3 cases done this week, right? Was that 3? started and ended on this week. Wow. All right, we're going to jump back. I think we had Judge Fleischer. Is he gone? Where'd he go? Wait. I think Judge Fleischer is gone. Oh, he's still alive. Okay. Let's take a quick peek and jump back with Judge Fleischer really quickly. Judge Fleischer, possibly the
Mr. Sanders, ready?
best dressed judge ever, I guess.
Keisha Lewis.
Yes. Come up, Miss Lewis.
We're going to get rid of the replay thing. This is live. There may be a Sarah Boone hearing. I'm not sure if we're going to see that or not.
So, tell me about the test, please.
Judge, Ms. Lewis had a medical marijuana card from Louisiana.
It makes no difference to me.
Your Honor, she does have lupus, so I think that's the reason she was given the prescription for the medical marijuana.
In Louisiana, great. But you're not in Louisiana. You're not allowed to use, and I made it a condition of your bond that you're not allowed to use. You're in direct violation of your bond. And no means no. You have a DWI. How do I know that you're not going to smoke marijuana, get another DWI with a marijuana case? Because it's don't matter. It doesn't have to be just alcohol. DWIs can be with marijuana. They can be with PCP. They can be with cocaine. They could be with whatever. It could be NyQuil. If you drink too much NyQuil, what does it do? You get intoxicated and you can pick up a DWI. It could be an Ambien DWI. It doesn't mean just alcohol. That's why we tell you not to use any intoxicating substances. Don't use illegal substances. So what all did she test positive for?
It was just THC.
Just THC.
She wanted to let the court know that she did submit the medical marijuana license and her diagnosis to her pretrial officer, and she just wanted to say she was trying to be upfront about it from the beginning.
We're not allowed to use. How old is this case?
74. 46 days old, I think.
Miss Lewis, in the state of Texas, it is still illegal, and you are not allowed to use it. If you have a problem with that, then go to the legislature and change it. But while I'm here, I have to follow the law. I've sworn to do it. And you are not to use marijuana. I get that you may have a medical condition, but you still can't use. I've ordered it as a condition of your bond. You are going to have to find another way to deal with that issue. There are plenty of other ways that you can treat that issue. Marijuana is not one of them. Do you understand? I do. And I'm going to tell you now, I'm going to test you 35 days. I will give you a pass today. But if I find that you use again, and I don't care what your excuse is, I'm going to lock you up. I don't like to put people in jail, but just some people just don't get it. And I don't know. You have to find another way to medicate, but marijuana is not it. You will get tested 40 days from today. And if you're still positive for marijuana, then I'm going to lock you up. Do you understand? So we will reset this case for 40 days. She'd come back in 40 days. We will test her again. Hopefully she's negative.
Thank you. That's all I have.
You're skirting thin ice, ma'am. There's absolutely no excuse. No alcohol, no marijuana, nothing. Nothing that has THC, CBD, nothing. Okay.
Right this way.
This is in Harris County, Texas. This Judge Fleischer. Quite the character. Quite the guy. runs his own YouTube channel, occasionally chats with people in the YouTube channel, has done interviews with other YouTubers. Shout out to Vicky.
Judge, you ready for the next one?
No, sorry. I need to send these bond conditions I've been waiting on. Sorry.
He's a snazzy dresser. A couple of you guys said Leisure Suit Larry. I thought it was something Hugh Hefner might have passed down. Legally Blonde, thank you very much. Gifting 5 membership. Appreciate Legally Blonde for you being in the courtroom. Obviously not today, but previously giving us great insight into that Ohio case. Love having quality court watchers like yourself available to the channel. It helps so much, and we love it. It's Jersey Boys. He normally wears a bow tie. This is a rare occasion to find him in a...
Julie, did you need her for amended bond conditions? We're just discussing here when you go back to court. November 14th. I'll make a note on our...
A long tie? A bow tie? Well, he's doing those bond paperwork signatures. BG, check-in from Inglewood, Florida. Inglewood! Our home was spared. No power since 3 p.m. yesterday. Others not so blessed. Please pray for our small fishing town. Oh, my goodness. BG, glad that you guys are safe. I know this cleanup is going to be a long one. And Florida gets hit so hard and so often. It's just one side starts recovering, the other side gets hit. And sometimes areas that get hit before, Fort Myers gets hit again. So crazy. Please stay safe.
Okay, I'm gonna bring it.
Caballero, come up, please. Annelies Caballero Martinez.
We've seen a little bit of spice from Judge Fleischer today, but he has more in him. He can really rip into you if you give any pushback. He'll get feisty, and I'm here for it. I love it. Apparently, by signing bond conditions, it means right click. What I like about Judge Fleischer is he resets emotionally between every case. Like he could be like leaning out of his chair, like coming out of his chair, like he is almost like going to come across the bench edge sometimes. He can be like that. And then when that case is done, it's dismissed. He'll be all smiles talking to his clerk and then start over from scratch with this person. Taste the rainbow, right? Delicious. I saw that clip. He got giddy when somebody's like tried to play the sob sit Admiralty Court line. He's like, "Oh, I've been waiting for this." It was so funny. All right. I think we might have to take a lunch break. There might be some Sarah Boone action this afternoon at the hearing, a scheduling hearing that was delayed from yesterday. It's Friday, so some courts, I think Cedric Simpson's doing his landlord stuff, which is always a little bit depressing, but sometimes funny. Why he doesn't wear a robe? I think the robe is really a tradition. It's a time-honored tradition, but it's not a law. I mean, a lot of what we do, I mean, the gavel, I think, is a tradition. It's not a law. Hoping for one more case with him before we bail for lunch. I think he's eating Skittles right now. Yep.
All right, for top of page 8, the SCADA, you said 2 weeks?
Yeah.
Is it for the cooling off period to reapproach on the moment? Okay. All right, Judge, we have page 17, films in the box. SCADA?
Because it looks like Tim's video.
We're going to break for lunch after this one if you can get one more.
It's there. It's Halloween. You can get it when you're done with it.
All right, let's do this. I see you sneaking candy. We see it. It's right on camera. And you're chewing.
Okay. On Sims.
Yes.
No, hold on. Tommy, you have the particular code section.
Yes, Judge. The section is Transportation Code 545.101, subsection A.
Oh, hold on.
Yes, Judge.
Page 17.
Thanks. Okay, 545.
545.101. Specifically, we're looking at subsection A. This is the issue when you're making a right turn at an intersection, such as what the defendant is doing in this case. Quote, subsection A states, to make a right turn at an intersection, an operator shall make both the approach and the turn as closely as practicable to the right-hand curb or the edge of the roadway. In this case, the defendant is alleged to have taken the right turn into the middle of the roadway as opposed to the right-hand side of the roadway, which is where she should have turned per the statute. So it is a violation of the transportation code, thus establishing probable cause for the officer to stop her that day.
A wide right? Turned right into the second lane?
To make a right-hand turn at an intersection, an operator shall make both the approach and the turn as closely as practicable to the right-hand curb or edge of the roadway. So where is she here? Is she at an intersection?
She is, and she's making a right turn, but that right turn, it's a 3-lane road.
But there's an actual intersection where there's lights.
I believe so. Is that correct?
I'm gonna look at that right now.
What's the address?
It's 145, there's the 14500 block of North Freeway Service Road. I believe that's the road that she turned onto.
Can you check this out?
Right there by the Chick-fil-A. That's in Conroe, Texas.
So Judge, we'd have to watch the body cam. It doesn't say where exactly she turned from. It just says the 1400 block of that street. So I don't know at this time if it is an intersection or not.
I don't think it's an intersection.
So.
Yes, sir.
It should be.
And Judge, we've scoured the transportation code. That is the only statute that we can see that fits.
Yeah, I get it. But from what I'm seeing on Google Maps, it's not an intersection. It's just.
We're just checking the in-car video, Judge, to see.
Take your time, no rush.
Next one.
And be careful with that one over there, you know? Hey, man, I just want to do this right. Come on, go.
Page 2, Alan. Except for Raymond Belton here.
Okay.
Holden said he was running late.
Okay, 4001.
Page.
Jacqueline Allen.
Page 3, you took in Augustine Winston Hawkins.
Oh, thank you. That's what I need to do. A bail order on that. Okay, so on Augustine, the harassment stays at 1,000.
Okay.
The failure to ID is now at 5,001. And let me do a bail order.
All right, sounds like he's got paperwork to do, so we're gonna bail on this judge. We'll be back. He'll be back. He's got some great stuff to give us, and he delivers almost every single day. All right. With that said, we are going to go to lunch. There may be Sarah Boone at 2, which only gives us about 20 minutes or so. So we'll check that out and see if that's going to happen. Also, I just got a notification that my gear going down to Trial TV Live is about to arrive, which is good because I have to start doing some work with them to make sure everything works properly, because I have to control it from here and they plug it in from there, and it's going to be wild. Let's see. I think that's it. We're going to take a lunch break. It is Friday. We might have a wee bit more to do after lunch break. It's going to be a short one, so eat quickly. Make it a short lunch. Just grab some leftovers out of the fridge or something like that. I've already had some Verdict music today, so it's a good day. Tonight, when you go home, please hug the people you love, smile at someone to make their day just a little bit better, and please stay safe till we go live again here in maybe 20 minutes with Sarah Boone. All right, that sounds good. Swedish Fish and Mountain Dew, both are gone. The Swedish Fish, the family size, devoured, and not by me. I ate half of them. We'll see on the flip side. I have not made the portal, so just make sure you've rung the bell. The bell has to be shaded in. Like if it's white, it hasn't been rung. If it's clicked it should be, I don't know. The bell has to be shaded all one color. That means you've clicked it. Enjoy lunch. You guys have a great one. We'll see you after. Bye.
Shame on you, sir.